Muzi, morning. Please turn off your camera. Muzi, morning.
Hello, Ian. Can you hear me?
Turn off your
Hard off, yes, I can.
your camera.
Yeah, long time no speak. How are you doing?
Okay, thank you. I'm going to just turn this down for feedback. Hold on.
Hello, Shani. How are you doing? There's some echo. Somebody's. Oh well, we'll fix that shortly. Okay.
So, Dolph, is the echo cured on your side? Or is there still an echo?
No, there's no echo at the moment.
Good morning, sir. How are you? Mr. Bartman, are you well, sir?
Yes, sir. Your speaker.
Good morning.
Good morning, Judge.
Good morning, Judge.
Are we ready to begin?
Yes, we are.
We are.
Paul, are you there? Please place the matter on record.
Good morning, Judge. Yes, I'm here. As the court pleases, my lady, this is a matter between the Special Investigating Unit and Cultiver Investments, Pty Ltd, plus 3 others, case number JP07 of 2019, appearing in the Special Tribunal of South Africa before Madam Justice Mudiba, 16 May 2022. My lady.
Thank you. Counsel may place themselves on record.
My lady, I am RJ Raad SC, appearing for the applicant together with Mr. Mtsweni.
Thank you, Mr. Roth.
Good morning, my lady. I am S. Stain, SC, appearing together with Mr. Curry for the first respondent, Cultiver Investments Proprietary Limited.
Thank you. Mr. Roth.
My lady, first of all, I'm just recovering from a rather bad bout of flu or sinusitis, so if I suddenly disappear, it will be because I've got to get rid of some coughing. I don't think it should happen because I'm just about fine, but if it happens, that would be the reason.
Okay.
I'm going to refer you to the heads of argument. Heads of argument. I haven't referred to the specific page on case lines. Do you have it, or should I refer you to it?
I've got it. I do have it. Thank you.
Now, you may have noted, if you've had occasion to refer to the heads, that we have, in a very specific sense, a very simple case, which is either good enough or not. We're not going to try and venture beyond that. In the heads, we start in paragraph 2, just referring to the fact that what it basically says is that our main relief, the main relief which we're seeking for and which we submit should succeed, is a setting aside specifically of the ministerial decision to have the lease immediately signed. And we make the point that paragraph 2, and that is of some importance for this matter, that the respondent is not the previous minister in person. It's the ministry. Now, we will refer to this again at a later stage, but it is, with respect, important to view the ministry as an institution. The ministry is as much an institution as is the department itself, which the importance of that is the following. It remains an institution irrespective of who the incumbent at any specific point of time may be. Exactly as the department will remain the department irrespective of whoever may be serving as the Director General or any of its other officials. So this case is not against the previous incumbent to that position who took the specific decision at the time. It's against the ministry as such for another reason which we will revert later. And then as consequential relief, we asked for the lease lawful and set aside. Now, paragraph 4, we refer you to what is actually the core structure, we would say the simple structure of our case. It's the following. The department and the previous minister, which I should actually reformulate to say the ministry under the previous minister opposed the previous application of law raising ominous indications of irregular malfeasance. The materials which would have served before the court in that matter represented a thoroughly tribal set of issues, necessitating the pronouncement of a court of law on their merit. And we will expand on that to a certain extent in our address to you, specifically as regards the tribal issues, the live issues, or is it sometimes referred to, especially in declarative proceedings, a live controversy, which required adjudication by a court of law, which was in fact in the process of being adjudicated on by a court of law. Then the ministry foiled the judicial process at the very stage when it was to commence, and we say that was in breach of the legality principle. Now, in paragraph 5, we list the facts, circumstances, and considerations upon which we rely, and we say it's either common cause or it's not, or it's not disputable by the first respondent. It starts, of course, with the cultivar applying for the benefits. That occurred, in fact, as far back as 2012. And then in February 2014, the Minister Coordinating Committee concluded that there was sufficient reason to launch an investigation of irregularities associated with the process followed. Now, I don't know to what extent your ladyship may have had time to look through the documentation and the record as such, because I could refer you to it, but it is in fact a letter written by the then Minister in which it refers to the to this meeting of the MCM, which deals with, refers to the fact that there's serious indications of serious irregularities which had to be dealt with.
Mr. Roth, I've gone through the papers, but I battled to locate annexures because some of the annexures referred to in the affidavits are inconsistent with the index. I couldn't locate them. So I would appreciate it if you can take me through the papers so that I do not miss anything.
Just a moment. The annex is LF5. We received the from yesterday.
Your sound is not clear. I don't know if I'm the only one.
I think it happens if I don't speak directly into the laptop.
No, I think,
my lady, we're also struggling a little bit to hear Mr. Roth.
Yes, I don't think it has to do with your voice. It's got to do with the sound of the device that you are using. It's unclear. I think your voice is perfectly fine.
Let me see.
Sounds a bit better now.
Is it a bit better now?
Yes, it is a bit better now.
I've tried to do it. Just for on case lines, if you would go to 001, page 739.
001 739, and that is?
That should be annexure L85.
Annexure?
L85 to the answering affidavit in the previous application. This is a letter written by the then serving minister in 20 to the Director General, and we should perhaps just read it. Because this is actually what prompted the investigation as a whole, and the fact that the minister wasn't willing at that stage to sign the lease as claimed by the first respondent in its urgent application, to which we refer as the previous application in our heads. Let me just quickly read it. The heading is Urgent Intervention Required, March Chicken Farming Operation. Attached here too, please Find the task team report dated December 2013, compiled in respect of Mike's Chickens farming operation referred to MCM, which is the Minister Coordinating Meeting by the NLARCC, which is the National Land Acquisition and I don't know whether it's recapitalization at that stage, coordinating council. This matter was discussed at the meeting of the MCM meeting on 11th February 2014, and the following decisions were taken in this regard. This matter is hereby referred to yourself for urgent attention and implementation of the resolutions taken by the MCM. An urgent forensic audit must be initiated in respect of this project, specifically in relation to the erosion of the state assets and alleged looting of bank accounts. The security deployment in respect of all movable assets must be verified and confirmed in writing to this office. Now, paragraph 4 is not quite legible. I'm ready to.
Okay, Mr. Roth.
It's paragraph 4, sorry.
I've located 001.
739.
Okay, the 739, is it, there's 2 page numbers there. Are you referring to the case line page number?
The case, I'm referring to the case
lines reference. Okay. Okay.
I've read paragraphs 1 to 3. 4 is a bit illegible on the case line version. I'm going to read it to you from a hard copy. A co-manager to the business must be appointed with clear terms of reference to stop the apparent looting, as well as to put in place measures to rescue the business in this regard. A team has been put in place and compromising the Chief of Staff, Policy Advisory Department's legal head, and the CFO put the necessary terms of reference in place. The branch REID must immediately take control of the business process environment. And the paragraph 6, the last paragraph reads, weekly reports must be submitted on progress made in respect of this intervention by the branch REID to this office. That's a letter written by the minister then, and it's dated it's dated 11 February 2014. Now, reports to which reference has been made by both parties throughout the history of this matter and all of the papers. That's reports by from Rensburg, Janssen van Rensburg, and by Deloitte and the NEF were all triggered by this instruction from Mr. Quincy at the time. Paragraph 5.3 of the heads. This led to the investigations, as I've just mentioned. Paragraph 5.4. On account of the findings of the reports, the department acting under the direction of the then minister refused to finalize and sign the agreement. And then on 24 January 2017, the previous application was launched, seeking an order compelling conclusion of the lease. And we should have added there, and payment of some 25 million rand in the recapitalization funds. Those were the 2 main prayers of that application. It was opposed by the department with the support of the then minister. In its answering affidavit, clearly hastily put together, as is always the case with respondents in urgent proceedings, already in footnote 4, we refer to the reality of the matter. Everybody in practice knows this, legal practice for some time. It's much easier to be the applicant in urgent applications than the respondent, because you can decide when you're ready, you can decide at what time period you allow the other side, and more often than not, not that I can't claim that happened in this instance, but quite often it's part of the tactical planning. It's just the timing allowed to the other side to respond. So that's why what we say in footnote 4. But in its answering affidavit, the department, having cited the applicable statutory prescripts, policies and procedures, and we've got the references there in footnote 5, relied on the findings made in the reports, which were very briefly summarized to the following effect. Now, we emphasize it was only very briefly done. And I think if one looks at the documentation to which we were referred to and specific references in those reports, one can see that it was just the basic bare essentials, which was mentioned in the answering affidavit of the department in the previous proceedings. And that was the following, which we referred to at paragraph 5.7.1.
Yes. May I suggest that you don't read through your heads, because that I've done.
I was not sure about that.
Yes, there's no need to read verbatim.
So in paragraph 5.7, we just referred to the very brief cursory summation in the answering affidavit of the department at the time of what those reports say. And that's at paragraph 571 to 573. And there's the reference at 5734 that the director's drawings and dividend declaration, not declaration, led the business to a position of perpetual liquidity. There was a problem with inventory, and there was a recommendation of an independent audit. That is where we were up at 5.7.3.6. But now, already in order to demonstrate that that was a very superficial summary of what those reports indicated. And the reason why we have to focus on that in more detail is, and I want to make that very plain, we're not arguing, we're not trying to argue now, contrary to what we said in our heads, that you have to decide on this. In fact, you can't. That application is not before you. The previous application is not before you, as if you have now to judge it. But you have to have regard, which we submit with respect, to the seriousness of what appears from elements in those reports to assess the weight or otherwise of our argument. But this was really a matter which had to be dealt with through legal process. The legal process which was pending, which was on the verge of being referred to oral evidence, to be dealt with thoroughly, viva voce evidence, and whatever else might come into play, and which shows that's the most important part of our case. Our case made that the decision, the political decision of the then minister was irrational, and was that she failed to uphold the rule of law. The rule of law required a court of law to pronounce upon these issues. And that is what she stopped. She nipped it in the bud. In other words, and we make the point elsewhere in our heads, the main problem is not the urgent application as such, which she put an end to. The main problem is the properly developed case, which was about to be processed, and which she stopped at the moment when that was to happen. Now, my lady, I've got to refer to a few references in those reports. If you would bear with me for a moment. I'll start with the Van Rensburg report. Now, I must confess, I'm going to try to do something which I haven't tried before on case lines. Let's just see if it works. Otherwise, I'll have to refer you to each and every page. If you would bear with me for a moment. Are you now perhaps on case lines looking at 010249?
Where do you want me to go on case lines?
No, I'm testing whether I'm able to take you there directly.
Okay.
If you look at case lines, are you perhaps looking at 010249? That's what I'm trying to do. If it doesn't work, I'll have to
No, it's not. Are you trying to display?
Yes.
Okay, no, it's not coming through.
Not coming through.
Yes.
Let me just try again.
Please give me that reference again so that I can also try and get there.
010
010
-249.
Please repeat.
010 -249.
249. Okay.
Perhaps it could be working now.
Still not displaying.
I just want to hear from our other participants whether they've got the page from my side now.
Yes, now it's displaying.
It's displaying for us as well.
Thank you.
If we look at the top bullet, there is no new business established. Mike's Chicken Pizza Limited is still running the business, even though the property.
I've lost the presentation. The page that you are displaying has disappeared.
Oh, gosh. Just a moment, my lady. What do you say?
It's back. It's back. Thank you.
Say again.
It's back. I can see it now.
Okay.
Can you also see it, Mr.
Mr. Ntweni is assisting me in this regard.
Yes, we can also see it. Thank
Okay.
you, my lady.
Thank you. You may proceed, Mr. Roth.
Can you speak?
I think I've followed out.
Mr. Rath, can you hear Mr. Rath? He's just sitting across my table. So
I can hear him.
Can you hear him through my computer?
Yes, I can.
I'll have to read you on your meeting. I've got to read you on your meeting. Just tell her.
Can you hear him?
Not clearly, actually. Mr.
Okay, so he's gonna rejoin. He's gonna
Okay.
rejoin. I think he.
Okay.
Yes. Okay.
You may proceed, Mr. Ra.
Can you hear me, my lady?
Yes, I can.
My lady, I've got some difficulty. If I want to go to the screen, the meeting screen, it disappears. Can I can you hear me?
Yes, I can hear you.
Can I ask for an adjournment of 5 minutes? I just sort myself out here. Sorry for this.
We adjourn for 5 minutes. Just checking if you are ready to come back, Mr. Rath.
Well, what happened is Mr. Mtweni tried to help us by some automatically referring you to the other participants at the page, and it mesmerized my view of the proceedings. I think I've worked out how to auto display to everybody. Let's just try that because it will save a lot of time.
Yeah.
Just a moment.
If the display does not work, you can simply give us the case line's reference number and then we'll go there ourselves.
Yeah, that's the normal way of doing it, but I'm trying to expedite it. Let's just see if it works.
Okay.
Okay. Can I just hear whether everybody is at page 253, 001253? Have you all got it?
Page number?
001253. Is that on your screen on case lines now?
253. We were at 010249.
Yes, but I've tried to redirect everybody now to.
Okay.
00.
We're not seeing your display. We're not seeing the display.
And now I'm just trying it this last time. Otherwise, I will just use the other route. Is it perhaps now on your screen 253?
No.
Not okay. But then I'll let's do it in the usual way. Let's go to 001. No.
I'm there. Waiting on you, Mr. Ruff.
Okay. Could you go to page 010249? We've been there. I just want to pick it up from there again.
Yes, I'm there.
And I've referred you to the first bullet at the top. There's no new business established. Mike's Chicken Pizza Limited is still running the business, even though the properties and stock belong to the DLD. If we could then go to 010, page 253.
Yes.
The top bold bullet there, the financial statements of Mike's Chicken for the periods 210 to 213 attached as Annex D2F respectively reflect the following. 2010.
I'm not sure if I'm with you.
010, page 253.
Yes. Or 010.
010, page 253.
Yes, I'm there now.
The bullet in bold at the top, the financial statement of Mike's Chicken for the periods 2010 to 2013 reflected the following. 2010, profit of 0.6 million rand, 2011 profit of 2.4 million rand, 2012. Now, 2012 is when during 2012, the first respondent applied for the benefits. It's a loss of 2.3 million rand. 2013, it's a loss of 16.4 million rand. In 2014, a provisional loss of 14 million rand, which you'll recall, if you look at the one of the main criticisms is a lack of a due diligence which was done at the time.
Yes.
And it speaks to that. The next is 010. All of these references will be 010. The next is page 259.
Yes.
If you look at the fourth last paragraph, it's a third last bullet. The NLARCC condition, now if you got that, is a first last light bullet, not the bold one. NLARCC condition that the allocation of the project was subject to confirmation that Mr. Twala is not to receive in Mpumalanga was not adhered to, as it was reported at the 25 July 2013 NLARCC that Mr. Twala has benefited as an individual in Mpumalanga. The next would be page 258.
Yes.
The bottom bullet. Mr. Kastein's monthly income was increased from 128,000 to 170,000 rand. And below that, Mr. Newens, now Mr. Kastein, Mr. Newens were the previous proprietors of Moist Chicken. The remaining shareholder was not paid a salary, and according to Ms. Erasmus, the financial accountant of Moist Chicken, he received an average amount of 200,000 rand, which is accounted against his shareholders' loan. From August 2013, it was paid a monthly amount of 250,000 rand as a consultancy fee. Now, this must be seen against the background. If you look at all of the references of a really struggling company, which was generating increased losses, as we've just referred to. Page 256.
Yes.
The second last bullet, the bold one, refers to the decision to have all of this investigated. And then the last one, the management report dated July 2013, received from Ms. Erasmus from Moist Chicken, reflected the following. The property, plant, and equipment reduced by 107 million rand to 8 million rand from June 2013 to July 2013, in a month's time. Again, my lady, all of this shows how important it was and how, I could say, unbelievably irresponsible it was not to have a due diligence done at the time when the property was bought in 2013. Not only the property, but the shares. Page 256, 256.
Mr. Roth. Can you hear me?
Yes, my lady. The second,
Yeah, I don't want to interfere with your presentation, but I think it's important that I let you know that I'm lost. I don't even know what you're dealing with. What would assist me if you could outline? Can I just?
What we're trying to do is to refer to you.
Can I just put this to you?
We refer.
Can I just put this to you so you know exactly what I'm saying? Yes. I suggest that you give me an outline of your presentation so I can follow, and then you let me know as you move from point to point. Because at this point in time, I can see that you're dealing with lack of due diligence, but I'm not sure of the structure of your argument. I don't know where you're going. So if you could just give me the structure of your argument, it will make it easy for me.
Very well, my lady. It is this. As I've said in the introduction of the article, our main case, in fact, our only case is this, that there was a pending litigation which concerned sets of tribal issues of serious nature, dealing with indications of irregularity in the history of the manner in which the first respondent's application has been dealt with. And that our main case is that the political decision of the then serving minister foiled that, which meant that whilst the previous minister was upholding the rule of law by having it tested, all of this tested in proper legal proceedings, that was nipped in the bud by the political decision of his successor. Now, in order to illustrate that, if you would, the papers are replete of references by both parties, references by Ms. Archery, who was the deponent, the then acting DDG of the department in the previous application. She referred to the brief, I referred to you in our heads to the paragraph in which paragraph 5.7, the very brief summary which she has extracted at the time from these reports, and which, because of their brevity, being as such the result of the fact that those papers had to be put together very hastily in urgent proceedings, because of the brevity thereof, and because of the different, let me call it, angles which the first respondent wishes to attribute to those reports. We're referring you to a selection of references just to illustrate that it really was that when that matter was referred to oral evidence in the end of 2018. I think it was about November, something like that. It was referred to oral evidence. What would have gone to the court on oral evidence was a very, very serious set of issues indicating irregularity and malfeasance. The reference was, as I've said, end of 2018. On 20 December 2018, the previous minister issued the political decision stopping it all, simply stopping it all, and instructing the department immediately to sign the lease, which was done in middle January 2019, I think the 11th, immediately, irrespective of this matter, which was about to be adjudicated upon by a court of law. So what I'm trying to do is to show you some brief references from these reports showing the seriousness of the materials which would have been canvassed properly in the ensuing proceedings when oral evidence would have been heard, had it not been for the intervention of the minister. That's what I'm trying to do.
Okay, yeah. And where's that? What are you trying to establish?
Just this, that if one looks at the answering affidavit of Ms. Archery, perhaps I could take you back to the headsman. Paragraph 5.7 of our heads.
Yes,
Now,
I'm there.
what we refer to
I can't hear
Sorry,
you.
my lady.
Can you hear me now?
Yes, I can hear you now.
What paragraph 5.7 deals with is what one will find in the answering affidavit of the then acting Deputy Director General of the Department, Ms. Archery, as it was hastily put together in the answering affidavit in the urgent application proceedings. And that's listed in paragraph 5.7 of the heads. I'm not going to read everything of it, but the 5.7.1 refers to what she said in the answering affidavit extracted from the Rensburg report. 5.7.2 does the same with the Deloitte report. 5.7.3 does the same with the NEF report. It's just a rendition of what she said in the answering affidavit. Now, our case is this. One shouldn't only look at that because that was really almost, we refer to it elsewhere as a makeshift case. One shouldn't look only at that, because it was the result of the fact that these papers had to be put together very urgently. The application was brought, I think, 21 January 2017. It was heard in 24 February 2017, when it was referred eventually to oral evidence. So what we're trying to do is, I've referred you to some references from the Rensburg report to show you that one should actually read the whole report to understand what the seriousness was of the findings which were made and the recommendations which were made. Now, I was trying to refer you to some extracts of those reports which illustrated. And in fact, what I want to do, I forgot what 2 or 3 references still on Van Rensburg, and then I want to refer you to the Deloitte report and the NEF report to do exactly the same. What I can do also is perhaps just give you a list of those references.
I think that would assist. In the interest
Yes.
of time, simply give me the list of the
So
references.
that you can, in time, just look at what is stated there. Do that. But anyway, what you will find in the references, which I'm still going to give you, is some attempts have been made by the first respondent to say that actually Van Rensburg and Deloitte recommended the lease to be signed.
Yes.
In other words, in exactly the same way which the minister did at the time. That's wrong. What happened is they list all of these irregularities and difficulties and the lack of due diligence. And then they say, this exposed the department to the fact that it's not in control of the matter. So the recommendation is get some lease in place, or at least a caretaker agreement, because the existing one has expired, to get a grip on the situation, which otherwise would just run away. That was the basis of a recommendation. Not that everything is okay and fine, as the deponent to the answering affidavit would have it, and that they agreed, in fact, that the lease agreement should simply be signed. That was not the effect of it. And that the references haven't referred to.
Where do I find that, Mr. Those recommendations?
This last one which I'm referring to.
Okay, I think Mr. Rath, I think I should just leave you to present your case. It seems like I'm interfering with your flow. Just present your case as you had planned to present it.
Can I just refer you on this last point to 010261?
Yes.
The third bullet.
Yes.
DRDLE currently has no control over its properties, assets and livestock as. There's no official from the DRDLE involved in the management of the project. The DRDLR is not represented on any management meetings with either Cultiver or March Chicken. To date, even though there's been no signed lease agreement, strategic partnership or a management agreement with either Cultiver Investments, the DRDLE has verbally and by approval agreed to a lease agreement with Cultiver Investments, which can be argued as being binding, which was what the previous case was about. To date, none of the purchased movable assets have been registered in the DRDLR's name. None of the purchased movables. We're talking about millions. And I think perhaps there's just one more on that. Well, but that's why if you read it towards the end of the recommendations, it's recommended that the lease agreement be signed. Not a long-term one, not the lease agreement for 30 years, but a lease agreement or a caretaker's agreement. But my lady, as far as the Lloyd is concerned, I'm not going to refer to take you to the necessary pages, but I'm going to give you the references and just tell you briefly what it says. Now, the Deloitte report starts by referring to the preamble of the PLAS manual, which says, the manual, I'm just reading it to you, the manual outlines guidelines and procedures that are necessary to implement PLAS. PLAS. While the manual serves as a guide to implementation.
Mr. Rath, sorry. In the interest, it's not necessary to take me through the whole report, which I have looked at. I'm simply asking you to take me to the references in relation to the aspects of the reports you rely on.
Yes, but the respondent, first respondent refers to the fact that the lawyer mentions that the PLAS manual is not, it's not cast in stone. There are guidelines. The Deloitte starts by saying that it's not a rigorous set of rules which must be applied with the such, which is correct. But then, if one goes to the report, you'll see that it's highly critical of the extent, in fact, of the extent to which the guidelines of the PLAS manual has been ignored by the officials. And what I'm going to do is they're going to give you just the reference, the page references, and a basic idea of what it says. The first is, these are all 001 references to the Deloitte report. Actually, the executive summary, which was next to the answering affidavit of the department in the previous application. If we would look at paragraphs 1.12 to 1.17 on that page.
On page?
Just make a note of it.
Please, sir,
that is
I need the page.
001.
Yes.
001, page 798. 001, page 798. What I'm now trying to do is to give you just a list which you can, if you would just make notes of it, and you could go through it in your own time, unless you want me to go through it now. There's there's a number of references which apply.
Yes.
So if you could just make a note there, it is page 001, page 798, paragraphs 1.12 to 1.17. The next is all these references are 001 references, all of them. Page 02, paragraph 1.43. The next is 804, paragraph 1.58 to 1.60. And the next is 809. We've got a problem here. 7. Problem is that the baselines page is illegible. And I've deciphered it. And all I can do now is to read to you what it says. We established, as is evident from the table below, that there was an increase in the salaries as a result of Mike's Chicken sale to the DRDLR, to the department. An increase in the salaries as a result of the sale. This further contributed to the losses suffered by Mike's Chicken in the period after acquisition, as the salary amounts appeared to be excessive. That's what it says there, but it's difficult to read it. The next is page 810. And that's where that part which I've written continues, particularly when considering the fact that Mr. News
your voice is unclear, sound unclear.
What I've read to you, which I've decided continues on page 810 with the following, particularly when considered the fact that Mr. News and Mr. Kirsten wanted to sell the business due to financial constraints. According to our agricultural specialist, the executive salaries appear excessively by roughly 30%. And then if you could just make the next note, it's on again on page 810, paragraph 1.100, which I'm not going to read to you. The next would be page 813, still 001.
Yes, proceed, Mr. Rock.
What I'm trying to do is to give you the list. If you could just make a note of the references which you can look at in your own time when you consider a matter. That's what I'm busy with at the moment. There are a few other references as well.
Yes, you may proceed.
It's page 813. 001 page 813, paragraphs 1.120 to 1.126. Now again, the part at the bottom is illegible, 1.126, and it reads, the former owners should have purchased 20% into Mike's Chicken business, but not merely retained 20%, as their former 100% was sold to the department for 137 million rand for the full purchase of Mike's Chicken as a going concern, and not for only 80% of Mike's Chicken. That's very, very serious content. Unfortunately, you can't read it in the... Do we have a hard copy of the papers, Mike?
Yes, I do. It's not logistically possible for me to refer to because it's such a large volume.
It's a large volume, and unfortunately, I must say so. I know my client is responsible for it, but it hasn't been bound together. There's some pages switched over and some wrong annexes as well. But this is, if you would look at the hard copy of this page.
If you can just assure me that the hard copy is legible. Is the hard copy legible?
You could, well, my copy, I could decipher. I could decipher from a hard copy, and that's what I'm reading now. But
You
it
read
says
813
it's now 813 is the case lines number, I think.
is paragraph 120.
1.122,
Where is this?
1.126.
One?
Paragraph 1.120,
Yes.
1.126. You could read all of it, but the illegible part is the important one.
Okay.
That's one.
During the T adjournment, I will look at the hard copy to see if it's legible.
Yes. The original page number is 803, 803, I think, because it's some of the page as well, but it seems to be 803. Oh gosh, I don't know why these papers have been prepared in this way. My lady, it's an,
now you see why I had actually
because,
at some point I just stopped reading because
yeah, you see page 804.
I battled with the papers.
The next page, 804, which should then be 8001814, also has a very important illegible part at the bottom. But let me give your ladyship because this is important. It's really important. Page 804, it's paragraph 1.131. Yes. 1.135. And the illegible part is again at the bottom. It reads, I'm not going to read the legible part, but the illegible part reads, proper background searches on Cultiver and its directors were not done. No other prospective beneficiaries were considered for the Mike's Chicken properties. This goes to the heart of the matter. It is evident that no beneficiary screenings and interviews was held with Cultiver before the recommendation for approval of appointing Cultiver as beneficiary was made to the NLARCC. Now this is illegible at the bottom of the original pagination 804. I just want to check.
It doesn't assist me if you refer me to illegible documents.
Yes.
It really is of no assistance.
Yes, I realize that, my lady. All I can say is if you could look at the original, maybe you would be able to decide. I can do nothing about it.
It's prejudicial to Cultiver as well.
I didn't hear you already.
It is
Just say again.
prejudicial. It is prejudicial to Cultiver as well.
I realize that. But that's all. I can do nothing about it, my lady. We come into this case at a late stage, and we've got to put up with what we've got. But is that if you would look at page 804 of the original pagination, which is the next one, you will probably be able to read the bottom of that page. The next one is page 815. I'm still giving you the list of references. I'm almost done. 815. This is now case line 001, 815 paragraphs 1.139 to 1.140. There are more, but I must refer you again dealing with the argument that Deloitte and Foresburg actually recommended the lease simply to be finalized. If you would look at page 001818, which should be the top of page 808, original interpretation. But there are 3 references left. I'm going to refer you to the 3 references on the record, and then I'm done with Deloitte. The first is 818 001 818. You'll see at the top there's a heading. There is no lease agreement which is a risk for the department. Paragraph 1.168, which is the third paragraph, which is a killing comment. It is, however, to the department's benefit that no long-term lease agreement was entered into with the beneficiaries. That speaks for itself. It is, however, to the department's benefit that no long-term lease agreement was entered into with the beneficiaries when they were appointed, as the department would have been in a different position than the current. It's a benefit that is not being done. So we can almost say, thankfully, it hasn't been concluded. And then, unfortunately, again, and I must, because this is very important, at the bottom of that page, it's rather difficult to read it, but what it says is, as there is currently no lease or caretaker agreement with Mike's Chicken or Cultiver, the state assets are exposed to risk, and it refers to section 9 of the main report. And that's the reason why on the next page, on 819, case lines 819, original pagination 809, paragraph 1.2, recommendations are the recommendation that the department.
Your voice keeps disappearing, Mr. Rath.
I'm sorry, I don't know to what extent the way you could have followed me, my lady, but I'm referring to, it's the next, it's page 001 819 on the case lines reference. It's page 809 on the original pagination, paragraph 1.172. Now, this is the paragraph upon which the first respondent ceases to tell the tribunal that actually the recommendation was of Deloitte was simply to sign the lease. It reads as follows. We recommend that the department immediately enter into a lease agreement with the beneficiary, alternatively enter into a caretaker agreement with the previous owners of Mike's Chicken, as there is currently no legal agreement or relationship between the department and Cultiver and or Mike's Chicken. Now, the reasons for that I've referred to already. It's been given in the report. The last reference to the Deloitte executive summary is the very last paragraph, paragraph 1.184 at page 810. The original of the pagination is 001, page 820. What it says, is paragraph 1.184. However, we did find that Mr. Twala does not fit the profile of being pro-poor as required by the second class framework. He holds directorships in 20 corporate entities and he is the owner of 12 vehicles registered in his name, referred to section 17 of the body of the report. That is a huge thing in the policy framework of the department. Of their own initiative, it's pro-poor. You find that repeatedly referred to in the manual, plus manual.
I can't hear you, Mr. Roth.
I say you find it repeatedly in the plus manual is that the basic driving philosophy of the entire system is pro-poor. There's no doubt about that. And that's the comment of Deloitte in that last paragraph, that Mr. Twala does not fit the, let us say, and that's my word, profile, which are beneficiaries to which the system is aimed, as he owns 20 directorships in 20 corporate entities, and he's the owner of 17 vehicles. That's their comment. But really, I'm not going. It's taken me a lot of time to go through those reports. I could do the same with the NEF. I'm not going to do it. The NEF reports is a short one. It's next to the papers, I think, as LA. It's LA 8. The original population. It is the case lines. It should be. I'll ask Mr. Mutuni just to get me the case lines reference of the NEF report.
Perhaps I can be of assistance. It's 001822. It starts at that page.
Yes.
Thank
I'm
you.
not going. Thank you very much. I appreciate that. But really, I'm not going to do the same as I actually should. But I would ask you, when you consider this matter, to just read quickly through that report. It's not an extensive. And you'll see that again, what Ms. Archery has extracted from it in the answering affidavit doesn't give a full view of what was involved. Already, I'm going back to the heads, and I'm going. There's no further references of that nature, and hopefully I'll proceed quickly. I see it's 11:15. Do you want to adjourn now?
Yes, let's adjourn for tea.
Until 11:30.
Until 11:30, yes.
Yes.
Thank you.
Are you with me, my lady?
Yes, I'm back. Are you back, Ms. Steyn? Thank you. Mr. Roth, I did have a look at the hard copies that were sent to me by your attorney during the tea adjournment, and the references that you gave me to the Deloitte report are mostly illegible on the report. That report is actually quite a bad copy. It is as bad as what is loaded on case lines.
My lady, yes, that's where I am then. I must say that the Van Rensburg report, which is at the 010 references, are quite legible. Those
Yes,
are
I have no difficulty with that. Yes.
Yes. What we could do, and I think perhaps we should do it because it's very important, is to have a retyped copy of the Deloitte report.
Is to have what?
A retyped copy of the Deloitte report in full. And let you and the opponent have it, and the first respondent have it.
So, my lady, we must object to that on behalf of the first respondent. It's really not helpful to be given a legible version of the document now, particularly when it would seem that the version that was attached to Ms. Archery's answering affidavit in the urgent limpopo proceedings was itself not legible.
My lady, I don't think that should be a problem, because
Ms. Steyn, I'm trying
to the extent.
Ms. Steyn?
Yes, my lady.
Please address me on prejudice.
Sorry, my lady. My learned colleague is purporting essentially to put a document in a version that hasn't been before the tribunal or the applicant, either in this forum or in the urgent proceedings before the tribunal. And it's simply unhelpful and prejudicial to have a document in a form in which it has never been placed before Cultiver. It's kind of recreating a reality that never actually existed.
You also don't have a legible document.
No, my lady, my lady, our copies are illegible, have always been illegible. And one of the complaints your ladyship will see that we made in the answering affidavit is that the documents that were attached to Ms. Archery's report were these incomplete, illegible versions of opinions from third parties that were never corroborated, either in relation to the opinion and certainly in relation to the underlying facts.
Okay. Mr. Roth?
My lady, the function of that document in these proceedings must be taken into account with respect. Our case remains that that was a document together with everything else which was about to be dealt with by a court of law. So it's not presented before you to make any findings on it. That's the first thing. So if my learned opponent says that in the original papers it must also have been illegible, I don't think one can say that, because it's quite clear that all of that has been reproduced for purposes of this case. And one knows what happened in photocopying voluminous documents of this nature. But even if it was, it's quite clear that if that matter proceeded to oral evidence, and to the extent that the same difficulty might have existed then, it could have been rectified, and it would have been rectified. The other thing is this: I'm not quite sure, but you'll recall that And next to the replying affidavit was the lately discovered documentation of Deloitte and von Rensburg. And I'm rather sure that the same same executive summary, which is this annex to which I've referred to, but definitely the full report with all of the supporting documentation was added to the 010 series of case lines. And that was given to the first respondent after they filed this answering affidavit, and they were given ample time to work through it, and to file a supplementary answering affidavit, which they did. But the supplementary answering affidavit didn't deal with those at all. So it's not as if this document is the only one before you. And I would suggest that there's nothing, for the purposes for which we want to offer it, there's nothing wrong with it. The purpose being that that was a document which would have gone to court if the proceedings hadn't been stopped. That's all. It's not for you to make any finding on it.
Ms. Steyn, I see you have your hand up.
Thank you, my lady. The only point I wish to make is that the submission that in due course, if the Limpopo proceedings had continued, that a legible version of this document would have been presented to the court is, with respect, completely pure speculation. One has absolutely no idea what may or may not have happened in those proceedings if they had continued, and what would not have.
But it doesn't address the issue of your prejudice now in these proceedings.
Yes, our prejudice remains. We were given, and we've had illegible copies, and that's a simple fact, and it doesn't assist us to now give us legible copies.
Mr. Rath?
My lady, Mr. Ntweni is just checking it, but I think that this same executive summary has been repeated in the 010 series when the author of the Deloitte report, Mr. Ramego, made an affidavit, and all of those documents about which the first respondent had been complaining were offered to them before they filed the supplementary answering affidavit. So I was just checking it. I'm not quite sure, but the full report was there because that was the complaint. The complaint was that the original papers only comprised the executive summary to which I've referred to, and we've got this legibility problem. And
is that version on case lines, Mr. Rath?
Say again, my lady.
What was provided to Cultiver? Is it on case lines?
All of it was, it's the 010.
Give me the page number so I look at it.
We would just take it alert. Let me just explain what I'm going to show you. There wasn't a complaint in the original answering affidavit, but all they had was this executive summary, and next to the answering affidavit of the department in those proceedings, without the source documents and without even knowing who's the author. You'll recall that to our surprise, we then discovered those documents, and as a result thereof, we filed an affidavit by Mr. Janssen van Rensburg, the author of his report, the full report with all of the source documentation, documentation upon which it was he relied, and the same applies to Deloitte. Mr. Ramego was the author of that, and he filed an affidavit as well. Now, Mr. von Rensburg's documents runs from 010-504.
Okay, hold on.
That's his affidavit plus supporting documents.
Sorry.
010.
Yes.
010, page 504. And it runs from Rensburg runs up to 010, page 1102. All of his documents. The same applies to Deloitte. It starts at 010, page 1103.
Okay.
And it runs up
This
to
is what will
010.
assist me, Mr. Roth. This is what will assist me. Are you able to take me to a legible version of the Deloitte report that has been furnished to Cultiver?
Okay, my lady, I'll let Mr. The question is actually whether the executive summary was repeated in his final affidavit. It may not be. Mr. Mtsweni, my junior, is now just looking at it. And I suggest that I go on with the rest of the argument and see if we can find it, and we'll tell you.
Okay, thank you.
My lady, I'm not going, since you've read our heads, I'm not going to deal with it in any detail. Paragraph 5.19 is just the culmination of the heads, which goes to the minister's decision. And I'm going to read through that quickly, because that's where we want to arrive in this case.
Yeah, you don't need to read through that. You can just make the point that you need to make.
Well, it basically describes and defines the reasons why we say she did not uphold the rule of law. It's simply the fact that all of these irregularities were to be tested in a court of law. By nipping that process in the bud, she must have reconciled herself with the fact that if the matter had proceeded as it should have, definite irregularities and unlawfulness may have been found. And notwithstanding that reality, she still made a decision, which we say, firstly, is irrational, and secondly, spells a failure to uphold the rule of law. That's what we say there, and that is basically our case.
Mr. Roth, in the Limpopo proceedings, there was no review application. It was an application to compel, wasn't it?
Yes, it was an application to compel the signing of the lease, as the minister did now and then, and there was another prayer for 25 million rand subsidy. I think it's in the form of a recapitalization subsidy. That was
so
the
it cannot be, as you say in 519.5, that the minister's decision destroyed the possibility to have the administrative decisions that have been taken in relation to the lease to be reviewed and set aside. That's not the relief you wanted there.
Well, lady, that goes to a certain extent. That goes to a certain extent to the other, as far as we can see, the main point of the respondents. And that is the decision known as the LA3 decision taken by Mr. Maflangu, I think on the 25th of May 2000, pardon, excuse me. If we refer to that, if you would just bear with me for a moment. That's part of the summary in our heads, my lady, is that paragraph 5.10 of the heads. Could you just go there? You see, within this history of this whole matter, there was this decision by Mr. Maflangu, but then I think Deputy Director General of the Department, to that Cultiver should be appointed the beneficiary. And we refer to that in paragraph 5.10 of the heads. That's just part of the whole history and of all of the documentation. And let me just read it because it's central to this matter. As far as the approval of the acquisition of the Mike's Chicken properties and the appointment of Cultiver as a beneficiary by the then Deputy Director General Maflango as per Annex LO3, the department's case was. That's now still in the answering affidavit. By the time the conclusion of the sale agreement on 5 May 2013, none of the pre-acquisition procedures as set out were complied with, especially the beneficiary selection process was not followed. The NLARCC decision and the MCM occurrence was not in place, as appeared from the Deloitte report. The approval per Annex LA3 was issued without the applicable departmental policies having been complied with. And in the event of the court finding that it represented an unqualified administrative action, the right was reserved to apply for a review and setting aside thereof. Now, that's as we understand the first respondent's case, it's a very important part of it. Because what they say is they apply the Oducral principle to it, and they say there hasn't been any review of this. So both the department and the SIU is bound to it. And for that reason, the minister's decision cannot be set aside. Now, that's the basic argument here is, and we will revert to that, is that no, that is no answer to our case. Because what you see there is in fact what occurred. The department reserved the right to have it reviewed, first, and second, that was part of what the court would have dealt with if the matter was allowed to proceed further, as it should. So it's in that context that we say that there may well have been a review of this matter before the court of law, if the matter was allowed to proceed, and that's part of the proceeding which was nipped
but
in the
to date,
bud.
that review has not been brought.
No, my lord, no, my lady, it's not been brought. It was the right to apply for a review was reserved by the department. It formed part and parcel of the matter of the case which was to refer to evidence. So the department was quite entitled, if the matter went, if it was processed as it should have been, would have been entitled to apply for a review. This was, again, an urgent application. At this stage, they only reserved the right to do so. But the department never had the opportunity to apply for a review because that capacity was destroyed by the minister's decision, that ability. It's just part of the bigger picture. But my lady, I will be referred to it in more detail later on, and perhaps you could, but that's where a possible review comes into the picture, the possibility of review at that stage. But in paragraph 6 of the heads basically spells out what we can explain here so far. There was a thoroughly tribal case ready to be dealt with. It was referred, and the timing is important here. It was referred to oral evidence towards the end of 2018. On 20 December 2018, the minister issues that she takes that political decision and issues the instruction to simply have the lease signed, exactly as Cultiver was claiming in the previous proceedings.
Yes.
And we say, as I've repeatedly stated now, that was not, by acting in that manner, she was not upholding the rule of law. Now we deal with, in more specific terms, paragraph 10 and further with the Annex LA decision to which I've referred to. We're just, excuse. Now, at paragraph 10, and further, we refer to the fact that the first respondent relies on the Oedekral principle, which is basically to the following effect, and that is a decision which may be wrong in law, illegal in law, still exists in fact. And if it is not set aside, it may legally support a subsequent administrative act based or grounded in that first decision or act. I think it's, if I could just go through the formulation in our heads, my lady, paragraph 11. In Oedekral report, quoted the following from Forsyth. An administrative act may, notwithstanding the non-existence in law, serve as the basis for another perfectly valid decision. Its factual existence, rather than its invalidity, is the cause, and there's reason why we emphasize that, is the cause of the subsequent act, but that act is valid since the legal existence of the first act is not a precondition of the second. In other words, the principle only finds application in the context of a later valid act which is founded upon, or differently put, dependent upon, a previous invalid act. In such circumstances, the later act, being an act consequence upon the first, cannot be assailed on the basis of the invalidity of the first act unless the later has been reviewed and set aside. Now, we say this is the following. What we say is this, paragraph 13. There are two interlocking problems with the first respondent's defense in that regard. First, the applicable part of the approved recommendation reads that the Deputy Director General Land Reform and Administration approves the appointment of Cultiver as the C for the property. And we said the appointment fell far short from the decision authorizing the act of concluding the lease such. Hence, that it is stated in the answering affidavit that the approval of the first applicant is subject to departmental policies, which, as I demonstrated below, have not been complied with in the event that this honourable court takes the view that LA3 amounts to an unqualified administrative action. Then, in that event, the second respondent reserves the right, in due course, to approach the court to review and setting aside thereof. But the more important point is the following, my lady, 13.2. The second problem with the defense is there is no nexus between the decision reflected in Annex LA3 and the conclusion of the lease. The latter did not follow consequentially upon the former. The decision of the lease was not founded in that decision. It was founded in a political decision and instruction, which was simply to conclude the lease irrespective of whatever may have occurred before. It may be apt to characterize it in the following terms borrowed from the law of contract. Through the Ministry's intervention, the decision in Annex LA3 became a thing written water. That's the one answer. But perhaps, my lady, I don't know whether you've had occasion to look at the notes which we've put on the case lines over the weekend.
No.
It's in the packet.
No.
Now, it's notes in response to the heads of argument of the first respondent. Just a moment.
Are you taking me to those notes?
I just wanted to check the reference on case lines. It is 054, page 89.
0?
54, page 89. 89. 89.
And what document is that, Mr. Rath?
But it was notes which we prepared in response. The heading is notes, the SIU's notes in response to the first respondent's heads of argument. We did that to facilitate the argument rather than just arguing it off the cuff. And we deal with that specific. It runs about 6.5 pages. And if we could refer you to paragraph 6 there, if you've got it on case lines.
Yes.
The heading is strenuous reliance on the decision in Annex LO3 and adequate principle. Now, our main point we've already referred to, and that's the fact that there's no nexus between that decision and the minister's decision. But what we say here again is paragraph 7. Cultiver skirts around the SIU's actual case. In the urgent application papers, the department expressly reserved the right to have it reviewed. That formed part and parcel of the reference to oral evidence. Both the LO3 decision and the department's reserved the right to apply for its review were encapsulated in the referred proceedings. By following the further proceedings, the minister also followed the department's procedural entitlement to rely on review. So those are the two aspects as far as Annex LO3 is concerned. First, there was no nexus between that and the minister's decision. The minister's decision was not grounded in or built upon Annex LO3. And second, and even if the minister had that in mind, then she's still open to that criticism. The decision of the ministry is still open to that criticism, that it should have been left to be thoroughly dealt with and canvassed and processed through proper legal proceedings. That is as far as that is concerned. Can I refer to the main heads? And I'm going to leave it they're self-explanatory. I'm not going to add anything here. I can just explain what we deal with further. Paragraph, page 16 of the heads, paragraph 15, there's the heading, the ministerial power. And I'm just going to explain to you what we say here without going to detail. Now, the reason why we dealt with this is that section 10 of the Act vests the minister. That's the main empowering provision which empowers the minister to, shall I say, govern the entire procedure at which the Act is aimed. All of its ends and aims. Now, what we deal with here is this. There's a distinction between, and it goes to the policies which we're dealing with in this case. There's a distinction between two forms of ministerial or executive policies. It's dealt with in the cases to which we refer to. The first is where it's policy, I could say, in the pure sense. For instance, it was decided that when President Mandela decided to have a commission on inquiry in the rugby matter, that was a purely executive act. Falls within the executive act, remain not administrative law. But when policy is issued and implemented, where there's implementation of an empowering provision by way of policies, then it is an administrative act. That's just as a matter of clarity. But in both instances, whether it's an executive act or an administrative act, in both instances, it's subject to the rule of law, and more specifically, the requirements of legality, and more specifically, the requirements of rationality as part of legality. And that's why we say that even taking into account that the minister was empowered to deal with this matter on the basis of the broad empowering authorization of Section 10, the Ministry was still bound to legality and still bound to act rationally. If you would, sir, bear with me for a moment. Paragraph 19, we refer to the Democratic Alliance versus President of the Republic of South Africa case. And there's a passage we quote there. But the main theme of that passage is this. Rationality review is an elevation of a relationship between means and ends. That's where rationality comes in. You've got means and you've got ends. And the two must be connected and dealt with, shall I say, globally, in a rational manner. So paragraph 20.1.2, that was the part of the criticism. I'm not going to read everything else. The political decision applied only to Cultiver and not even represents a policy decision as such. Now, I must interrupt myself there. The first respondent argues no, but that notification also requested the department to report on all other outstanding leases. So it's not, it didn't only apply to Cultiver.
Where do I find that, Mr.? Where do you deal with that in the because that's evidence, right? Whether it applied to Cultiver or not is evidence.
My lady, I'm going there. I'm going to deal with that exactly in a moment's time. If I could just conclude this.
Yeah.
The point made here is this: it is not as if a new policy or regulatory system was put in place. It was only applied, the lease was granted to Cultiver, not on the basis of some new policy or new regulatory dispensation. That's why we've got the heading at paragraph 20.1 of the heads. The entire complex regulatory system was simply ignored. But then 20.1.2, it cut across the complete regulatory system of legislative and policy measures, which were developed and evolved over time, the means to safeguard in equal measure in both the interests of the state and the interests of the countless of competing applicants, upon whose upliftment the policy of the entire structure of the Act and the policies issued under it is focused, the ends. So that's why we say there was a disconnect between the means and the ends in the decision of the Minister, which renders it fell short of the requirements of rationality and therefore of legality. I'm not going to read the rest of it, my lady. Then in condemnation for delay, I'm not going to deal with that. The argument there is only one we've got. It amounts to the following, that from the SIU's point of view.
No, I don't think you need to take me through the condonation argument. I think it's clearly set out in your heads of argument.
And then lastly, as far as the main heads are concerned, we refer you to the argument of the first respondent that even if the application succeeds, effectively the lease should be left intact. And we refer to the Brightwater case, which is to the following effect, and that is, even where the Constitutional Court was inclined to leave the financial and legal position of the impairment of the contract, which had been declared unlawful and set as unlawful, intact. It only applied to rights and benefits which is accumulated up to the time of the order. It cannot cover, Section 172(1)(8) does not empower the court to preserve the contractual rights of such a contract, which still had to be exercised in the future. So when it comes to a lease, The lease is set aside, and that's all of it. That's where it ends. That's what we do with the Brightwater case on page 27. So if the application succeeds, there's only one order which could be made, and that is the lease is declared unlawful and set aside. That's it. Of course, I may add, but
why should I not be concerned about the consequences that flow from that declaration of invalidity?
My lady, the fact of the matter is simply this. And maybe I should just address you on that point from a different angle, and that is just the implacable demands of constitutionality. And there's a case which explains that very quite a few constitutional court cases which demonstrate that. Of course, all pay matter is one of them, which simply says there's no room, there's no escape, so to speak, if that's my language. If a matter is constitutionally unlawful, it's got to be declared unlawful, and that's it. You could say irrespective of the consequences. So, for instance, just to demonstrate how strict the constitutional demands are applied by the Constitutional Court. The Buffalo City case is a case in point. What happened there is this. Buffalo City contracted ASLA to erect some housing project in a certain township. Nothing wrong with that. Bidding process was followed. Everything was perfect. But then a contract which Buffalo had with another contractor in an adjacent township went sour. So Buffalo City then took the decision and agreed with ASLA to extend the contract so that it would cover the adjacent development as well. Nothing untoward, no fraud, only you could say a technical problem because of the prescripts which hadn't been followed in the appointment of ASLA. It was as innocent as you could imagine. And yet, because of the demands of the Constitution in terms of Section 217, that contract, the one extending the housing scheme to the adjacent region, was found unlawful and set aside. In that context, the court decided that what has been earned by ASLA up to that stage could be retained. And that's the difference which the Supreme Court of Appeal in the Brightwater Props case drew between that situation and the lease. Perhaps, my lady, I could just read to you it's paragraph 27 where we deal with it. Page 27, at the top of page 27. That case is in all fours of ours. It's exactly the same topic, kind of problem which we have in this case. The Court of Appeal declared the lease in the matter unlawful, but exercised its discretion in favour of the lessee by not setting it aside, thus preserving the lessee's rights which have already accrued to the lessee. Yet, the order it issued effectively allowed the lease to continue for its 20 years duration. On appeal, Brightwater's counsel relied in this regard on the decision of the Constitutional Court in its statement information in the Gijima matter, as it is known, and the Buffalo City matter. In both instances of which the innocent service provider, which had not been aware of the internal irregularities committed by officialdom, as was Brightwater, was allowed to retain the remuneration received for work already done, but not to continue and exercise their future rights in terms of the contracts found to have been unlawful and invalid. Emphasizing that Section 172(1)(b) does not allow the discretion to be exercised in order to preserve the continuation of future rights, Brightwater's argument was rejected, and the order of High Court substituted by one simply declaring the lease agreement constitutionally invalid and of no force and effect. But it's not an expression which one often finds in the legal domain, but it has a mechanical function. It's a mechanical result. If it's found to be unlawful and set aside, that's it. Now, of course, it's a question which presents itself for an answer. What will happen if we succeed? Well, all one can say, or we can say, or anybody can say is this. There's a certain situation on the ground, on that property, with the businesses. There's a department which will have to deal with it. No doubt that the practical exigencies of the situation will compel both parties to deal with each other and find the best possible solution. But that will be up to them. That's not for this court to deal with. And I would suggest, in terms of the Brightwater decision, that's all there is. One aspect, for instance, is the following. It was mentioned in the answering of David that if the application succeeds, then there would be enrichment claims against the department. I suppose pertaining to certain improvements, which was perhaps new buildings or whatever, improvements on the property. That is so. That is so. And then, if that is so, then let the legal principles pertaining to enrichment run their course.
Mr. Rath, I don't agree with you that I can simply not be concerned about the effects of the declaration of invalidity, because the whole just and equitable regime is to ensure that the court is to accord the court with a discretion to ameliorate the effects of unlawfulness that flow from an unlawful decision. Now, are you saying to me all that the SIU wants at this stage is for the department no longer to be bound to the lease agreement?
Madari, my problem is this. What the Brightwater case says, and maybe I haven't made myself clear enough. What the Brightwater case says is this: the equitable jurisdiction provided for in section 172(1)(a) stops at the setting aside moment. That's why it doesn't exist afterwards. It cannot be applied forward. That is why the judgment refers to the Buffalo City matter, where the contractor was allowed to retain the profits and the benefits up to that stage, but that's where it stops. So when you deal with a lease agreement, if it's unlawful and set aside, again, that's where it stops. Section 172 has no application from there on further. So that's why, in that case, the Supreme Court of Appeal had exactly the same problem, as far as I understand it, and it came to the conclusion that...
Well, that's not the Constitutional Court's jurisdiction on this principle, and I see that this case was decided in 2021. It's a fairly recent decision. Doesn't seem to accord with the Constitutional Court's jurisdiction on this issue.
Madari, it's not impossible.
Jurisprudence, rather. Yes.
Yeah. If it's got to be changed, if that ratio of applying section 172(1)(a) and B is to be changed, then it will have to be by the Constitutional Court, which is not impossible, of course. Of course, it may still find its way there, but as we deal with this matter now at this stage, that's the law to which you are bound with respect.
Anything further?
All I can say is this. I think one can rest assured that if that lease is set aside, then the practicalities of the situation will compel the parties to deal with it at best, as best they can. And that's the main argument. My lady, there's a few other aspects which I'm done with the main heads. I just want to refer you to the notes.
Perhaps you can do that in reply, Mr. Roth, because those notes are essentially that, isn't it?
My lady, I think I do need. I think I do need to deal with two matters because it goes to the heart of the matter, and I don't think it would be correct for me to wait until reply. It won't take me long. The one is the complaint about hearsay evidence, but relying on hearsay evidence, and the other is the complaint that the previous minister hasn't been interviewed. Now, those are two important issues.
Yes, those issues are raised by Cultiver. So let
Yes.
Cultiver argue them, and then you will then deal with them.
Very well, my lady.
Thank you.
That's been our argument. At this stage, we, of course, do ask for an order, setting aside, that's prayer 2 and prayer 1 of the notice of motion, setting aside the minister's decision and declaring the lease unlawful and setting it aside.
Thank you.
And ask for costs, including the costs of
Thank you. Ms. Stein?
Thank you, my lady. My lady, there are two components to this application. The first is whether the decision of the former minister to withdraw the opposition to the Limpopo proceedings and to instruct the finalization of a written lease agreement with Cultiver should be set aside because it's irrational. And the second only arises if your ladyship finds for the SIU on the first ground. It is whether, even if this decision is set aside, the written lease agreement between Cultiver and the department concluded in January 2019 should follow suit. We've dealt with these issues fully in our heads of argument, my lady, and stand by all of the submissions in our heads. And given that our heads are comprehensive and your ladyship no doubt will have read them, I'm not going to read the heads, and I'm only going to address your ladyship on certain parts of our argument, and I will endeavor to do so relatively briefly. My lady, in relation to the first question, the first component of this application, being whether the former minister's decision should be set aside, our first and our primary contention is this claim should fail because there is no evidence before this tribunal that identifies either what the actual content of this decision was, and more fundamentally, what the reasons for the decision were, and what facts and information the former minister took into account. In these circumstances, it is not permissible. It is simply not permissible to conclude that the minister, or as my learned colleague would have it, the ministry, acted irrationally. There is simply no basis for such a conclusion. But secondly, my lady, we make the point that as there is no evidence properly before this tribunal, the entire discussion about whether the former minister acted irrationally takes place completely and impermissibly in the realm of speculation. But even so, we postulate that speculation, even speculation, is far more consistent with the conclusion that the minister's decision was a rational one. And very briefly on this point, My lady, the first fact is that in May 2013, Cultiver was appointed as lessee and beneficiary of the PLAS program in respect of the properties. Unlike the decision of the former minister, which the SIU would like to set aside, we have actually seen this decision. My lady, it's Annexure LA3, and it appears at page 001723 to 779 of, that's the case lines reference. And if I can briefly take your ladyship to it, it's in the Friday the 13th note submitted by the SIU. They refer to it as the LA3 decision, and we will use that terminology as well. But your ladyship will see that if you turn to page 001729, which is the final page of the memorandum, your ladyship will see that, sorry, it's the final page is 730, but there are approvals on 729 and 730. But what is approved is the appointment of Cultiver Pty Limited as lessee for the properties. So, my lady, in May 2013, Cultiver was appointed as lessee and beneficiary of the PLAS program in respect of the properties. Then, if I can ask your ladyship to please turn to page 00171 of the papers. And my lady, this is a reference to the PLAS manual that is an annexure, it's annexure BA3 to the founding affidavit. And your ladyship will see at page, it's at page 00185 of that document. I'm not sure if your ladyship is there.
Yes, I am there.
So, my lady, just to go to the page before, your ladyship will see that this is dealing with methods of acquisition.
Yes.
Referring to how the state will acquire the land proactively. And then turning the page, oh, sorry, my lady, I'm referring your ladyship to the wrong reference. I wanted to, sorry, it's page 88 of case lines.
Okay, I'm there.
Your ladyship will see under the heading, the subparagraph B, leasing.
Yes.
The first sentence says, lease agreements with an option to purchase must be concluded with selected beneficiaries. Lease agreements must be concluded with selected beneficiaries. So, my lady, in May 2013, Cultiver is approved and appointed as a lessee and a beneficiary. And your ladyship has seen that the PLAS manual expressly requires that a lease agreement must be entered into with an appointed lessee. My lady, it's unclear why a lease agreement was not entered into already in 2013 or 2014 with Cultiver. But we can speculate, given that in this exercise that we're engaging in an exercise of counter speculation. We can speculate that the reason for this is because there was a problem with the department's systems at the time. So a department not relating to Cultiver, a problem not relating to Cultiver, but a problem relating to the department's systems. And my lady, there's support for this speculation, and that support appears at page 001818 of the papers, which is, my lady, it's part of the Deloitte.
Give me the volume in case lines. It's not simply
sorry,
001. Is it 1, 2, 3? What volume is it? Sub volume.
In 001 part 5.
Sorry, my lady, it's in 001 part 5, I'm told.
And you said page number?
The page number is 808.
808.
Sorry, my lady, 818. I'm getting confused. My papers, it's the pagination and it's page 818, 001818.
Okay, trying to get there. Give me a few seconds, please. Yes, I'm there.
So, my lady, under the heading conclusions at paragraph 1.166, it's noted that it's a concern that at the time of appointment of Cultiver as beneficiary, again, recognition that there was an appointment of Cultiver as beneficiary, as we saw in Annex LA3, a lease agreement could not be entered into, as according to DRDLR officials, the department's lease system could not supply a lease agreement. My lady, then we know from the papers that the farming operations were experiencing financial difficulties, in no small measure due to external factors affecting the industry as a whole, such as the exponential increase in the price of feed, and financial assistance was applied for. It was this application for a grant that triggered 2 investigations and reports, both in 2014. That is the Van Rensburg internal investigation and then the Deloitte investigation, and both of which concluded that a lease agreement should be entered into. In any event, by 2016, the department had started to engage with Cultiver in respect of a long-term written lease agreement. At this time, however, the department's policy had changed in that rental was now required to be determined with reference to an approved business plan. And if I can take your ladyship, please, to 001689. I'm not sure what volume that is.
689.
Yes. It's in volume 6, I'm told, my lady.
It's in the same volume, 689. Yes, the same volume.
689.
Yes.
Sorry, if I can just.
Are you referring me to the lease disposal policy?
Yes, my lady. Your ladyship will see the document starts at 689. It's the state land lease and disposal policy. And if your ladyship turns to the end page of that document.
On what page is it?
Sorry, my lady. It is at page 722. Your ladyship will see that the date of the document is 25 July 2013.
Sorry, I'm still trying to get it right. 722. Yeah, I see that.
So this was after the appointment of Cultiver as lessee and beneficiary. And then, sorry, my lady, I'm just trying to find my reference here. Your ladyship will see that page Trying to find the provisions dealing with the rental. Sorry, my lady, at page 705, 001, 705, at the very bottom, of that page, paragraph 9.4, your ladyship will see that there now is a requirement that all lessees shall develop business plans, which will then form the basis for the determination of rental. And such business plans shall be reviewed by the Provincial Technical Committee and approved by the NLARCC. And if your ladyship turns over the page and your ladyship doesn't, I don't need to take you to it now, but your ladyship will see that the purpose of approving the business plan is that the rental was going to now be determined with reference to projected net income based on an approved business plan. So, my lady, in 2016, 2 years after the Van Rensburg report and the Deloitte report, the department starts to engage with Cultiver in relation to the conclusion of a written lease agreement, and the department sent Cultiver a copy of a lease agreement to sign in about May or June 2016. But there was a holdup in finalizing it because of the requirement to approve a revised business plan for the purpose of determining rental in accordance with the policy that I've just referred your ladyship to. And my lady, if I can refer you to paragraph 79 of the answering affidavit in this regard, it's at page 00932. And my lady, I don't need to take you to that paragraph. It's just if your ladyship is happy to just note the reference just for the proposition that the department had actually sent Cultiver a copy of a lease agreement
79
to sign.
You deal with it at 79.
It's at it's paragraph 79 of the answering affidavit, my lady. And my lady, the draft lease agreement that was sent to Cultiver in May or June 2016 is Annexure MT11 to the answering affidavit. And that document appears at 009104. And again, my lady, it's not necessary to go to that document at the moment. But incidentally, and I think it's important possibly to make the point that the allegation that in June 2016, the department, including Mr. Ngwengwe, who signed the final lease agreement in January 2019, but the allegation that both he and the department already in 2016 were engaging with Cultiver with a view to finalizing a long-term written lease agreement is common cause in the Limpopo proceedings. And I can refer your ladyship in this regard to paragraphs 44.36 to 4.42 of Ms. Arch of Mr. Twala's founding affidavit in the Limpopo proceedings.
Please give me that reference again.
It's paragraphs 4.36 to 4.42 of the founding affidavit in the Limpopo proceedings. And my lady, the page number is P001 408. And it runs to 410. And that needs to be read together with Annexure MT10 to that affidavit, which is at page 001595, and Annexure MT11, which is at page 001613. And the response from Ms. Archery in her answering affidavit is at paragraphs 149 to 153 of her answering affidavit, and it's at pages 001662 to 001663. But my lady, the simple point is that in 2016, about 2 years after the Van Rensburg report and the Deloitte's report, the department starts to engage with Cultiver in relation to the conclusion of a long-term written lease agreement. But there's a hold-up in finalizing it, and the hold-up in finalizing it is the necessity for a revised business plan to be approved in order that rental can be determined. Then, my lady, at around this time, the NEF conducted an investigation into the farming operations. And my lady, in its own words, and I'm going to take your ladyship to that reference, but in its own words, this investigation was a superficial and cursory investigation, but more importantly than that, this investigation had absolutely nothing at all to do with the lawfulness of Cultiver's appointment as a lessee and beneficiary in May 2013, per the LA3 decision. And if I can refer your ladyship in this regard to paragraph 13 of the replying affidavit, and it's at page 0107.
Yes, I'm there.
So your ladyship will see that Mr. Avenant, in his replying affidavit, says when he approached the NEF, he received the following email from the General Counsel of the NEF. It says, I've reached out to my colleague who was part of the team in this matter, and below are the sentiments which he expressed. I don't want to go to court for this thing. I wrote a report after a short site visit and assessment of the financials that were given to us. I further went on to say that we cannot take a view on the business activities until a forensic audit has been concluded. I cannot comment on people's fitness to be a beneficiary or otherwise, or whether the issues we observed at the time were confirmed to be proof of improper conduct. But my lady, the really important point that I want to make, and your ladyship will read it from the NEF report, which my learned colleague has referred your ladyship to, is that the NEF report was not concerned with, did not consider, did not opine on the lawfulness of the appointment of Cultiver as a beneficiary in May 2013 in accordance with the decision LA3. My lady, Cultiver had by this time become desperate, and in January 2017, it instituted the Limpopo proceedings to compel the finalization of the written lease agreement, which required only that the business plan be approved for the purposes of determining the rental that had to be paid. There was already a draft agreement that had been given to Cultiver, and that was the outstanding issue on that draft, the determination of the rental amount. Cultiver also sought permission to pledge assets, and it requested a financial assistance, I think, in the amount of 25 million rand. As your ladyship knows, the department opposed this application. In relation to the finalization of the written lease agreement, its primary ground of opposition in relation to that aspect of the case was that the rental could not be determined as the business plan required to be considered and approved first. My lady, and as your ladyship raised with my learned colleague, the department did not at any point seek to set aside the decision appointing Cultiver as lessee and beneficiary, being the LA3 decision. That was not part of the Limpopo proceedings, and there was no count of application, and there was no relief sought by the department in that regard. The application was then referred to oral evidence. By December 2018, and my lady, this is now almost 2 years after the Limpopo application had been instituted. Your ladyship will recall it was instituted in January 2017. So we're now in December 2018. And at a time when there is no suggestion at all that the oral proceedings were due to commence, my lady, there isn't even evidence of a court date. As at this date then, December 2018, the department had still not sought to set aside the decision appointing Cultiver as lessee, being the LA3 decision of May 2013. But by this time, the policy in relation to the determination of rental for the purpose of lease agreements had changed. The express change was that rental was to be determined not anymore in relation to a business plan that required to be approved, but now rental was to be determined only in relation to the price of the acquisition of the property. And if I can refer your ladyship in this regard to Annexure BA14, to Mr. Avenant's founding affidavit, the reference is page 001932. I can find it. My lady, does your lady...
Trying to get there. 932.
Yes, the document starts at 932 and it...
Almost there. Yes, I'm there. It's got a heading target group towards the end, right? Is that the document?
Sorry, my lady?
Oh, no. I'm on the wrong page.
No, it should say Annexure BA14.
There are two pagination systems, so I keep forgetting.
Yes. So the one is the big.
I'm there. It's a document, Department of Rural Reform document with reference 19411. Is that the one?
Yes.
Okay.
And my lady, if your ladyship will turn over the page to page 933, your ladyship will see that it says, during December 2017, the PLAS terms and conditions was approved, which introduced a different rental determination approach that only requires the NLAACC to approve the land acquisition price from which the rental is determined. This effectively meant that all leases that had not yet been converted as envisaged in the policy would be going to the NLAACC for categorization only. And my lady, if your ladyship will have regard to page 001944.
Yeah. Yes, I see that.
It says agricultural leases, with the exception of those mentioned in 7.2 and 7.3 below, shall pay a rental amount of 1% of the market value of the property. And then there's it says, in case where the market value cannot be reliably established without incurring expenses, the cost of acquisition shall be utilized. And then your ladyship will see as well that when they talk about the different categories, what is envisaged is, if your ladyship turns back the document a little bit to page 942, there are 3 categories of lessees.
I see that.
And at the very bottom, category 1, households with no or very limited access to land. Category 2, small-scale farmers who are farming or intended to farm for subsistence purposes. And then you'll see category 3 is medium to large-scale commercial farmers who've already been farming commercially at various scales, but are disadvantaged by location, size of land, and other resources. And then your ladyship will see a bit further down, any person who is in category 3 will automatically qualify for a long-term lease with an option to purchase. So, my lady, the new rental system that's envisaged is one where simply all that needs to be done is you work out which category a lessee falls into. Categories 1 and 2 don't have to pay any rental at all, but when you're in category 3, when you're a medium or large-scale commercial farmer, then now the rental to be paid is determined with reference to the market value of the property, or if that's difficult to determine, with reference to the acquisition price of the property. And then going back, my lady, to the start of the document at page 001932, sorry, or back actually to 933, your ladyship will see that in the second paragraph, it says the department has a target of finalizing the signing of all leases on PLAS land by 30 November 2018. So my lady, the point that I'm really making at this stage is that by December 2018, almost 2 years after the Limpopo application has been instituted, at a time when there's really no suggestion that the oral proceedings are due to commence, there's no reference to any court date, the department still hasn't sought to set aside Cultiver's appointment as a beneficiary and lessee. And as I indicated to your ladyship earlier, the PLAS manual is clear. If you are appointed as a beneficiary, a lease agreement must be concluded with you. The word used is must. And at this stage now, the policy in relation to the determination of rental has changed. It's no longer necessary to approve a business plan for the purposes of determining rental. So, my lady, at this time then, the former minister had no lawful basis to refuse to enter into a written lease agreement with Cultiver. The excuse that rental could not be determined because a revised business plan needed to be approved in order to ascertain the projected net income and from there work out what the rental should be had fallen away. On the contrary, and in accordance with Odacrol, the former minister was obliged as a matter of law to give effect to the extant decision of May 2013, in terms of which Cultiver had been appointed as a lessee of the properties and in circumstances in which a lease agreement must be entered into with an appointed lessee. And my lady, in the SIU's Friday the 13th note, one of the points that they make is that they say that Cultiver overrates Odacrol. And with respect, my lady, I think the situation is more correctly that the applicant underrates Odacrol. The SIU fails to recognize that as a matter of law, that as a matter of lawfulness and compliance with constitutional obligation, until such time as the decision LA3 was set aside, the department was required to give effect to it, and its failure to do so was unlawful and unconstitutional. And your ladyship has the reference to Odecroll. This point is made also in the majority decision in Kurland, which is also one of the cases that we refer to in the heads of argument, and I'm sure I don't need to take your ladyship to that case. So, my lady, it is of course true that in order to avoid complying with her lawful obligation, the former minister could have insisted that an application be made to set aside the decision LA3. But it is respectfully difficult to comprehend how her failure to do so, even as a matter of speculation, and again, my lady, I want to stress all of this, this entire discussion happens in the realm of speculation, but it's difficult to comprehend how her failure to do this, even as a matter of speculation, can be considered to be irrational. It is even harder to comprehend how her settling legal proceedings in which no application to set aside the decision LA3 had been made, albeit that this could maybe, possibly, at some point in the future be raised, certainly hadn't been, could ever be irrational. And there are a number of important facts that need to be emphasized in this regard. The first is that at no point prior to the institution of the Limpopo proceedings in January 2017 had the minister or the department sought to set aside the decision Annexure LA3. On the contrary, they had taken a number of steps to implement it, including permitting Cultiver to occupy the properties as a de facto lessee, and then in 2016, engaging with Cultiver with a view to concluding a long-term lease agreement. And that, my lady, is 2 years after the Van Rensburg report and the Deloitte report. Even after the institution of the Limpopo proceedings in January 2017, and prior to the appointment of the former minister, no steps had been taken to set aside the decision LA3. So, my lady, by the time the former minister, decided to withdraw the opposition to the Limpopo proceedings, more than 5.5 years had passed, during which nobody had applied to set aside the decision LA3, including the SIU, my lady, who by this time had had about 1.5 years to investigate matters pertaining to the acquisition of the Mike's Chicken properties. When the SIU then did eventually bring an application to set aside the decision LA3, which they did before this tribunal, almost 7 years after the decision was taken, and more than 2.5 years after the SIU was appointed to investigate the Mike's Chicken acquisition, they then elected to not persist with this review. Again, creating a situation in which there is no lawful basis for the department to not implement the decision. LA3 appointing Cultiver as lessee of the properties. And the simple point, my lady, then is of all of this is that if therefore it were permissible for this tribunal to resolve this case and to make its decisions on the basis of speculation, speculation would yield the conclusion that the former minister's decision was completely rational. And I'm going to refer your ladyship, I'm not going to read these parts of the heads of argument, but my lady, this is also dealt with in paragraphs 21 and 27 of our heads of argument, and I refer your ladyship to those paragraphs. I'm not going to read them. But of course, my lady, and then returning to our primary point, And as we've pointed out in the heads of argument, this tribunal is not permitted to make its decisions on the basis of speculation. The law requires that they be made on the basis of evidence. This is in all instances, and particularly in instances in which there is undisputed prejudice, not just to Cultiver, but to the hundreds of people that it employs and the community that depends upon it for this continued employment and Cultiver's ongoing farming operations. And in this regard, it is our respectful submission that no evidence has been placed before this tribunal that would permit of the conclusion that the former minister's decision is irrational. Indeed, there's no evidence as to the actual content of the decision itself, and even less what the reasons for the decision were, or the factors and the information that were considered by the minister. This tribunal remains in the complete dark as to what the minister's reasons were and what process was followed and what facts and information was considered. My lady, we make the point in our heads of argument that there's no admissible evidence even as to what the content of the decision that the minister actually made is. And in paragraph 206 of our heads, we cite the recent decision of the Supreme Court of Appeal in LA Group Proprietary Limited versus Stable Brands Proprietary Limited. And we cite this decision for the respectfully trite proposition that hearsay evidence is not evidence at all. This is reinforced by many prior decisions of the Supreme Court of Appeal, two of which are quoted in the LA Group and Stable Brands decision. The first is a decision of Justice Schreiner in the Vulcan Rubber Works, in which he said unequivocally, clearly, hearsay, unless it is brought within one of the recognized exceptions, is not evidence, that is legal evidence at all, which quotation was repeated and expressly endorsed by Justice Cameron in the SCA decision of S versus Ndlovu, which is also cited in the LA Group versus Stable Brands case, and we refer to the relevant paragraphs in our heads of argument. Calling what is, in fact,
what should I make of the fact that the department is not defending the minister's decisions in these?
My lady, the department's not defending the minister's decision, but the department's also not opposing the SIU's decision to abandon its application to set aside Annexure LA3, the decision Annexure LA3. With respect, my lady, one can't read anything into the fact that the department isn't opposing, other than the fact that there is no version from the department. Certainly what it does not do is excuse the SIU with its very, very powerful arsenal of tools from placing before this tribunal any evidence upon which to review and set aside the decision. The fact that the department isn't opposing does not somehow exonerate an applicant for a review, particularly an applicant that is itself an organ of state with substantial powers, from placing a proper, cognizable, sustainable case before the tribunal. And my lady, your ladyship will read in the Friday the 13th note submitted by the SIU that they somehow seek to get around the fact that the only evidence that they put before this tribunal at best is hearsay evidence by referring to it as direct evidence. But this obviously doesn't help. Calling what is, in fact, and in substance, hearsay evidence something else doesn't change or alter the nature of its content. My lady, I see it's almost 1 o'clock.
Yes, let's take the lunch adjournment.
As your ladyship, please.
30 or 45 minutes? I don't think we need to take the full hour.
Yeah, my ladyship, we're happy with either. We're
okay. Ms. Rath, how long?
I didn't quite say until what time? Till what time?
I'm asking if you are comfortable with a 30 minutes adjournment or 45 minutes adjournment.
30 minutes would do. That's fine.
30 minutes. Okay. We're back at 1:30.
As your ladyship pleases. Sorry, my lady, I was having issues with my camera, so
No, that's fine. We're here now.
Sorry, my lady. So just to sort of place in context where I was in the scheme of the argument, it was just to set out the law regarding. So we were making the submission that no evidence has been placed before this tribunal that would permit of a finding that the former minister's decision is irrational. And then I took your ladyship to cases that make it very clear that hearsay evidence, unless it falls within one of the exceptions and unless an application is brought to admit it, does not constitute evidence at all. So then, my lady, if I might just turn to what is before your ladyship on the papers, or rather what isn't before your ladyship. And my lady, the first submission is that on the papers there is no document from the former minister that purports to set out what her decision in fact was, far less any evidence from the minister confirming what the content of her decision was. There is also no evidence from a witness that was present when the decision was taken. There isn't even evidence from a witness who was. My lady, I don't know if that's.
I don't know what would have caused that.
Yeah, I'm not sure. It seems to have gone away. Can your ladyship hear me?
Yes, I can hear you, but it sounds like there's a third voice coming through.
Yes, I
apart
don't.
From the echo, apart from the echo.
Yes.
Seems to have gone now. So proceed.
Yes.
The echo is still there, though.
Is the echo still there?
No, it's not there now. Okay. Let's see how it goes.
Okay. So, my lady, the first point is that there's no document from the former minister that purports to set out what her decision is. No evidence from the minister confirming what the content of a decision was. There's no evidence from a witness who was present when the decision was taken. And there isn't even evidence from a witness who was told by somebody else.
But what about the email? There's email content.
Yes, my lady, I'm going to.
Yes.
Yes, I'm going to get to those emails, my lady. But so really, my lady, that the high watermark of the applicant's evidence of the decisions are the two emails. It's Annexure BA8 and BA10 from Mr. Mokone, who is the head of the ministry.
Yes.
But my lady, these emails don't constitute evidence of the former minister's decision. They don't even constitute evidence of what Mr. Mokone understood the decision to be or had been told what the decision was. And it's for a very simple reason, my lady. It's because there is no evidence before this tribunal from Mr. Mokone. There is no confirmatory affidavit from him. Then, my lady, what you have in the papers is the deponent, Mr. Avenant's version of what he was told by Mr. Mokone, Ms. Siddiqui, and Mr. Mngwengwe. But that is also not evidence of the content of the minister's decision. And this is for more than one reason. Firstly, Mr. Avenant's version as to what these witnesses told him is classic hearsay, and as such, on the authorities, not evidence. But secondly, his inadmissible double or possibly even triple hearsay version doesn't even extend to what the content of the decision was. Rather, it's confined to the single proposition. And my lady, this appears at paragraph 76 of the founding affidavit. And you don't need to turn to it, my lady, but I'll just give you the reference. At paragraph 76 of the founding affidavit is at page 00153. And what he says is that a summary, and that's his word, a summary of what these three officials said when questioned by the SIU is that they simply acted on the instructions of the former minister. So Mr. Avenant doesn't even...
He doesn't elaborate on what the instruction was.
No. So he doesn't even purport to summarize, he doesn't even summarize what they say the instructions were, far less to summarize anything that the witnesses might have told him about what the decision was, because the decision is different from the instructions. And we made the point that there was an instruction in relation to this matter to withdraw the opposition and to finalize Cultiver's lease agreement. The SIU had speculated that this decision somehow, that the decision that preceded the instruction somehow only related to Cultiver. But your ladyship will have seen, even with reference to the policy, the change in the policy and the circular that I took your ladyship to, that reflected a policy in relation to a range of lease agreements, not just Cultiver. So again, that's just, another area in which it just
Except that the issue with Cultiver, if you look at what the policy says, right? There's a change of policy in terms of rental. So lease agreements have to be regularized in terms of that policy. The difference with Cultiver is that at that point, Cultiver did not have a written lease agreement, right? So its case would have been slightly nuanced from that of others who had lease agreements and simply had to be brought into the new regime.
That's correct, my lady, but again, we're speculating, because there may have been others who had written lease agreements that needed to be brought into the new regime for the purposes of rental determination, but there might have been others who didn't have actual written lease agreements yet. The only point, my lady, that I make in relation to that is that it's all speculation. So when we get to what the content, we know we have some version. And again, it's even in relation to what the instruction was, there is not proper evidence before your ladyship. But at best, there is a summary from Mr. Avenant of what other people told him that the instruction was that they were given. There isn't even a summary of what the decision was. And again, even if there had been a summary of what somebody had told Mr. Avenant the decision was, that would be inadmissible hearsay evidence. So the only point that I make to your ladyship in relation to not knowing whether the decision preceding the instruction was limited to Cultiver is that there's so much that we don't know. We don't know what the decision was. We don't know what facts were taken into account. We don't know what information was before the minister. So at best, what one has is a document, which is an email setting out an instruction that isn't confirmed by the person who wrote the email. And then you have Mr. Avenant who says, well, certain people told me they acted on the instructions without even going further and saying what they said the instructions were. But even if they did, that would obviously be hearsay and would be inadmissible. But we don't even have a summary of what anybody told Mr. Avenant the decision could have been. So in short, there's no evidence, my lady. That's really the simple point. There's no evidence before this tribunal as to what the content of the former minister's decision actually was, and even less. And this probably is the.
But your case, you are saying the instruction was to process the lease agreement. Right?
The instruction was to withdraw the opposition. Yes. And to finalize the conclusion of the lease agreement that had already started, that was premised on LA3.
What evidence do you rely on for that?
I'm going to take your ladyship there. If your ladyship doesn't mind bearing with me.
Okay.
So my lady, in short, we said there's no evidence as to what the content of the decision was, and even less that were possible. There is absolutely no evidence at all regarding the reasons for the decision and the information that was considered in the process. There is, in respect of that, my lady, there is literally zero. In the place of evidence, what the applicants put before this tribunal is nothing more than Mr. Avenant's speculation based on his extrapolation that the decision was political and his interpretation of emails that are themselves not evidence of the reasons for the decision or the facts that were taken into account. So in the ultimate analysis, on the basis of inadmissible hearsay accounts and rank speculation, your ladyship is asked to declare that a decision of the former minister is so irrational that it fails to pass the legality threshold. And with respect, my lady, we submit that this shouldn't be countenanced.
I'll tell you what concerns me about this minister's decision is the apparent incoherence with the decision of the previous Minister Nkwinti. But Minister Nkwinti orders an investigation, right? He ordered investigation of Cultiver for a number of reasons, and then that becomes the basis for the opposition by the department in the proceedings in Limpopo. And then you have a different minister comes in and seems to undermine all of that and insists that the lease agreement has to be finalized.
So, my lady, if I can unpack that a bit. So there's a suggestion, and it appears, I think, up front in the summary of the applicant's heads of argument that Mr. Nkwinti refused to sign the lease agreement. Now, my lady,
but he didn't only do so. He ordered an investigation because there were allegations of impropriety.
My lady, there were 3 investigations.
Yes.
The 2 investigations took place in 2014. Those investigations, 2 years after those investigations, the department was engaging with Cultiver regarding the finalization of a lease agreement. And on the paper before your ladyship, there is evidence on these papers that isn't refuted that the minister told Cultiver that we're going to regularize the lease agreement.
Which minister?
Then my lady, Minister Nkwinti.
Nkwinti. Okay, take me there, please.
If your ladyship will, it's in the answering affidavit. Oh, sorry, my lady. Your ladyship will. Bear with me. It's at paragraph 77, at page 00931.
Paragraph?
Paragraph 77. But my lady, if I can, it will be, your ladyship will see the last sentence in that paragraph.
But this is based on, is it Mr. Twala, the deponent? Is it Mr. Twala? Yes.
Yes.
It's based on his say-so.
Yes, it is. But that's his version, that this is what he was told. But it's not just, sorry, with respect, my lady, it's not just based on his say-so, actually, because your ladyship will see that in 2016, a lease agreement was sent to Cultiver. Your ladyship has seen that lease agreement, and I'm going to take your ladyship to the correspondence around that lease agreement. So your ladyship will see that the department was engaging with Cultiver in relation to the signing of that lease agreement. And your ladyship will see, and your ladyship would ask me, and I'm going to take your ladyship to it again, when I say that the discussion about the lease agreement preceded the Limpopo proceedings, that the issue was the determination of the rental. The issue was the business plan for the purposes of determining the rental. So with respect, my lady, it's not just Mr. Twala's say-so, because after this, after what he says the minister said to him, the department sent him. And it was actually Mr. Mngwengwe who engaged with him, amongst others, who actually sent him a copy of the lease agreement. But my lady, in relation to the issues that arise from the Limpopo proceedings, my lady, there were a number of issues in that application. The lease agreement, the application to sign the lease agreement was just one of those issues. There was also an application for approval to pledge assets, and there was also the refusal of an application for a grant for the 25 million. And with respect, my lady, many of the issues that arose, that when the NEF report was commissioned, that was in response to the request for the funding, for the additional funding. And I've made the submission, but with respect, my lady, it's actually apparent from the content of that NEF report. That report was not concerned with whether or not Cultiver had been lawfully and properly appointed as a beneficiary and as a lessee. So the Limpopo proceedings, there are a whole mix of arguments, many of which don't go at all to the question of Cultiver's entitlement as a lessee and its entitlement to a lease agreement, but concern rather the application for the 25 million rands worth of funding. And my lady, the simple fact is that yes, the former minister might have been of a different view. I'm not clear. As I say, to me, when I read those papers, and again, this is a speculation, what emerges is that the decision to not finalize the lease agreement, they weren't setting aside the appointment of Cultiver as beneficiary and as lessee. The primary opposition to that was what we need to do is we need to consider your business plan for the purposes of determining rental, and the whole finalization of the lease agreement is premature. And then they did raise sound and fury, but it's at points it is almost, too incoherent to follow. But what is clear in relation to this decision of this former minister to withdraw the opposition and to say that the lease agreement should be finalized, what is clear is that we don't know what the minister took into account. There is, again, my lady, there is nothing. There is absolutely nothing in all of these papers that would give your ladyship even an inkling of an idea as to what the process was, what facts were taken into account, what information was considered. And the SIU would submit that because it was a so-called political decision, well, that means that nothing was taken into account. With respect, my lady, that's clearly wrong. That's clearly wrong.
The minister's authority is not challenged, right? It's simply the basis of the decision that is being questioned.
Yes, my lady. They say that it was irrational. And our response to that is, well, in order to reach a conclusion that a decision is irrational, you need to know what was the decision and you need to know what were the reasons. And here, there is no admissible evidence of either of those two things.
Despite all those reports and evidence.
So, my lady, in the ultimate analysis on the basis of inadmissible hearsay accounts and rank speculation, your ladyship is asked to declare that a decision of a former minister is so irrational that it fails to pass the legality threshold. And with respect, my lady, that just cannot be. It just simply cannot be. And it should also be mentioned that there's no excuse at all for the failure of the SIU, with its vast array of powers, to have placed before this tribunal a case based on evidence. rather than hearsay and speculation. And the most glaring example of this, even more than the fact that they didn't even bother to obtain full copy of the investigative reports that they now try to rely upon prior to bringing this application. Not to mention that they didn't take any steps to verify the facts upon which those reports are based. Because, of course, my ladies, those reports in and of themselves aren't evidence. All they do is they show that at some point a document was written in which somebody whose conclusion is not binding on your ladyship found certain things. And in many respects, the Deloitte conclusions contradict the Van Rensburg conclusions. But certainly what we know is that the SIU took no steps to even get the full reports or to verify the accuracy of the facts upon which those reports were based. But perhaps the most glaring example of the SIU's failure to, with all its powers, to have placed before this tribunal a case based on evidence is the fact that they did not even attempt to contact the former minister. The submission in the SIU's Friday the 13th note is that this failure should somehow be laid at the doors of the current minister and the department, and with respect, that doesn't withstand.
They're the investigator.
They're the
investigator.
They're the investigators. They are the applicants for a review, and it is the SIU as an applicant for review that is required to make out a case sustainable in fact and in law for the relief that it seeks. And they have clearly failed to do so. And then, my lady, the second component of the case, and as I said at the outset, if your ladyship accepts, as respectfully Cultiver contends that your ladyship should, that there is no basis in law to set aside the former minister's decision as being irrational. If your ladyship accepts that it's not necessary to even get into the second component of the case, but if your ladyship is against us on that, then the second component arises, which is whether, if the former minister's decision is set aside, the written lease agreement nonetheless should stand. And my lady, in relation to this part of the argument, I will address your ladyship's former query regarding the submission that the process regarding the lease agreement had started to take place, the written long-term lease agreement prior even to the Limpopo proceedings. So, my lady, the simple point that we make is that once the decision to approve and appoint Cultiver as lessee, the LA3 decision, stands as a fact, that is all that is required to render the performance of Mr. Mngwengwe, a functionary in concluding the written lease agreement in January 2019, valid. The instruction of the former minister is respectfully a proverbial red herring. Even if one draws a line through it, as the SIU would have this tribunal do, the conclusion of the lease agreement in January 2019 is still valid because it relies for its validity only upon the fact of Cultiver having been appointed as a lessee in 2013 in terms of the LA3 decision. And your ladyship, and this, I think, my lady, is an answer to the question you'd asked me previously, but your ladyship will have seen from the papers that the final lease agreement, and if I can take your ladyship to that agreement, which is at page 001875, it's annexure BA11 to the founding affidavit.
001?
001875. Sorry, I don't seem to. I think I misplaced it. So my lady, 001. 875. Does your ladyship have
I was
it?
looking at the wrong volume. Must move to the next volume. Is it volume 6?
Is it
Yes,
my lady.
0016. Is it 0016? Okay, I'm there. That's the lease agreement.
That's the final lease agreement that was signed. That's the lease agreement that the applicant would have be set aside in these proceedings. But your ladyship will see, and I'm not sure if it's possible to do this in case lines, to do it virtually, but physically, if your ladyship will then look at Annexure MT11 to the answering affidavit.
Where do I find it?
That is at 009104.
Zero zero nine. Zero. Did you say 009?
Yes, my lady, 009.
Are you referring me to an annexure to the answering affidavit?
Yes.
Page number?
It's, sorry, my lady.
009, page number?
104.
Yes, I'm there.
And sorry, my lady, if your ladyship even just turns a few pages before that to MT10, Annexure MT10, which starts at 009101, your ladyship will see that there's correspondence between the department and Mr. Twala in relation to the finalization of the lease agreement in 2016, talking about the business plan and the projections. And you'll see, I hereby request you to send me the rental determination business plan. But then, my lady, so the 2016 lease agreement is the document I've referred your ladyship to at page 009104. And your ladyship will see, when comparing this 2016 lease agreement that was sent to Cultiver, but that was delayed from being finalized because of the need to approve the business plan in order to determine the rental. And this is before the Limpopo proceedings, before the new minister, or the former minister, took up her role. This is under the reign of the previous minister, Minister Quinty. Your ladyship will see that these two lease agreements are substantially the same. The primary difference between the two is that in the one, the rental is determined with reference to the business plan. And in the other, there's just a number that is given for the rental, because as in the final version, and your ladyship will see that that is in accordance with the amended lease policy, which reflects rental as a function of either the market value or the acquisition price of the property. So my lady, we make the submission then that the conclusion of the lease, the minister, the former minister's decision, instruction, is a red herring. You can put a line through it, because the validity of the lease agreement in 2019, just as the validity of the lease agreement in 2016, had that agreement been finalized. The validity of those agreements depend on the appointment of Cultiver as a lessee and beneficiary. Already in 2013, in terms of LA3, at a time when the policy makes it clear, a beneficiary is entitled or must be given a lease agreement.
So, Ms. Steyn, just help me understand this. So you are saying, since LA3 is not impugned, I shouldn't concern myself with, so there's no question about the basis on which Cultiver was determined to be a beneficiary that led to the conclusion of LA3. And because Cultiver is a beneficiary in terms of LA3 and an approved lessee, then a lease agreement was properly concluded with it. Is that your case?
That is our case, my lady. And
if
you
I might, at that point, there's no basis to attack. In these proceedings, because the process leading to the conclusion of LA3 is not under attack. It's too late to attack it on the basis of the conclusion of the lease agreement.
Yes, my lady, nobody's ever attacked it. For a brief period, the SIU attacked it, and then they've abandoned their attack. So with respect, my lady, if you take the former minister's decision out of the equation, you have a decision, a valid decision, that says Cultiver is appointed as a lessee and a beneficiary of the PLAS.
Is a caretaker. Is a caretaker, and to be a caretaker.
No, my lady, the decision.
Is it not? Yes.
No, with respect, my lady, Cultiver was appointed as the beneficiary entitled to a lease agreement. Your ladyship will see from the PLAS policy document that in the initial phases, because one's dealing with a land reform project, in the initial phases, there's sometimes a caretaker.
Yes, caretaker. Take me to LA3, because my recollection of LA3 is that it is a caretaker memorandum.
My lady, LA3, see. Okay, my lady, at LA3 is at page, it's 001729.
Give me the sub-volume as well.
Sorry, my lady. Volume 5.
Page?
Page 001723. That's where the document starts, my lady. And then
yes.
And then, my lady, at page 001725, paragraph 3.3.
This document, again, is not legible. The case lines version, which is the same version sent to me, not legible.
My lady, my version.
It's got dark patches on some text.
Yes.
Then paragraph 3 on page 726.
Yes, 726, but your ladyship will see page 725 and 726 are repeats of each other, and 725 is legible.
I assist. My lady, can I assist?
Yes.
It's indeed correct. I think it's indeed correct that such a decision was taken. We don't dispute that. And you will find it on page 00130.
What are you saying, Mr. Ruff? What are you saying?
I say, I just want to help because we've got a problem with the record. It's indeed correct that such a decision was taken, and I just want to refer you to where you can see it on case lines. That's on 001-730. That's where you find the final decision on a recommendation signed by Mr. Maflanga.
That document is also not there. It's got dark pages. You want to see my version? You can see, right? Can you see those dark pages?
It's repeated on 729 and 730 are repeats.
Mr. Roth, I need you to have a look at this so that you can appreciate the difficulty I've endured in preparing for this matter. Can you see? The hard copy sent to me is
I see it. I think my microphones are on simultaneously. All I want to say is that, and that's in fact a concession to the first respondent.
Yes.
There is a decision here signed by Mr. Maflanga. Let me just get there. It starts with the recommend. That's the page which is not quite legible. It starts with the recommendation. It's recommended that the Deputy Director General, Land Reform and Administration, 6.1 approves the acquisition. That's of all the properties, all of those farms. Then 6.2 approves the appointment of portion. Those portions again. That's a recommendation. Then you've got at the bottom recommendation 6.1, and it's indicated as approved. And recommendation 6.2, which is the appointment of the C, it is also indicated as approved, and it's signed on the 27th of May 2013, which is perhaps an important date to remember. 27 May 2013 by Mr. Maflanga, the Deputy Director General Land Reform. This is a decision which the department reserved the right to have on review. But the decision is here. That's what it says. And in that regard, 120 is with respect correct. I just wanted to help as far as this is concerned.
I appreciate your assistance, Mr. Roth, but my difficulty in the manner in which the SIU has presented this case is that numerous documents are not legible, and that has prejudiced me in my preparation. So, I mean, this approval is referred to in the founding affidavit, right? It is referred to, but there's a reason why documentary evidence is annexed. It's important to understand the full context. It's important for me to have regard to the content of the approval.
Thank you. So, my lady, can I ask, is your ladyship able to read? Is your ladyship able to read page 725? Is that legible?
725. No, it's actually the last paragraph I can't read.
Yes, but the last paragraph, my lady, is actually irrelevant. It just says application for acquisition. It's almost like a footer. It doesn't.
So where are you referring to?
So in paragraph 3.3, your ladyship will see proposed land use.
3.3 is on the following page.
It's actually the following page and this page are a repeat of each other. So this page is actually legible. It's the following page, which has those terrible black lines down the side, is a repeat of this page. So,
okay. Where are you taking me to?
To page 725, paragraph 3.3.
Yes, I'm there.
And your ladyship will see in the second paragraph there, it says for the proposed land use, that the property would be leased by the company Cultiver.
No, I'm not with you now. Are you reading on 726?
725, my lady, 726 is illegible.
My 726 is legible. If you are reading,
So then,
which paragraph are you reading from?
3.3. It says proposed land use. That's the heading.
Seven two six. This is how 726 looks.
Yes, and my lady, in 725, the page before that.
Okay, that's better.
So my lady, 725 and 726 are actually the same page, but 725 is illegible. It's a legible version. So under proposed land use, in paragraph 3.3, your ladyship will see in the second paragraph that it says the property would be leased by the company Cultiver, would be leased. So the proposal is for Cultiver to lease the property.
Okay, what
then,
document is this?
My lady, it's the same document. This is part of Annexure LA3. This is part of the decision of 27 May 2013, okay. LA3, appointing Cultiver not as caretaker, my lady, but as lessee.
Okay.
And then your ladyship, if your ladyship will turn to page 730, and I'm not sure if I can help, the relevant part is paragraph 6.2, the second paragraph. I understand your ladyship's version is bad. Mine is also not fantastic, but I can read it. And if I might just read it to your ladyship, perhaps to assist.
Yes.
Paragraph 6.2. So your ladyship will see that what is approved is approves the appointment of Cultiver Pty Limited as lessee for the property. And then what follows is a description of what the property is.
Yes.
So my lady, your ladyship is correct that there was then a caretaker agreement for a limited period. And the point that I was making to your ladyship in that regard is that in terms of the policy, in terms of the PLAS manual, and I think even the subsequent policies, because this is a land reform initiative, for a limited period, often there is a caretaker in place while the lessee, kind of comes into the property and starts to, take occupation of the property. And sometimes the lessee can be the caretaker, but sometimes the caretaker will be somebody other than the lessee. So the only point that I'm making is that the caretaker agreement for a limited period doesn't detract from the fact that Cultiver was appointed, yes, as a lessee, and it was appointed in terms of this decision, which nobody has sought to set aside. In fact, the first time anybody sought to challenge this decision, it was the SIU in these proceedings, which they have then abandoned. So then, my lady, to get to the point that I was addressing your ladyship on, which is that even if you set aside the minister's decision, the conclusion of the written lease agreement in 2019 is valid. The point is that the validity for that agreement is this approval in 2013, appointing Cultiver as beneficiary of the PLAS program and appointing Cultiver as lessee. And perhaps I can illustrate it in another way, my lady. If this decision, LA3, had been set aside, the fact that the minister or anybody issued an instruction to sign a lease agreement wouldn't be a sufficient basis in law for the written lease agreement. What you need is you need an approval, you need an appointment of Cultiver as lessee. The minister never purported to appoint Cultiver as lessee. What had happened is that Cultiver had been appointed as a lessee. We saw that the initial hiccup in the lease agreement was because the department's systems couldn't generate a lease. Then there was the various investigations in 2014, but by 2016, the department was engaging with Cultiver and had given Cultiver a written lease agreement. This is all implementing the 2013 decision. There was a roadblock in terms of the Limpopo proceedings. But once that was removed and the final lease agreement was signed, which is in substance identical to the 2016 agreement, except for the rental determination, the validity of that lease agreement is the decision appointing Cultiver as lessee in terms of Annexure LA3. And my lady, in terms of Annexure LA3, and I'd referred your ladyship to the policy which says that where you've been appointed as a beneficiary, a lease agreement must be entered into with an appointed lessee. So we make the point in our heads of argument that if you put a line through the minister's decision, the former minister's decision as the SIU would have, and one sets aside the lease agreement as the SIU would have, you're in a situation where Cultiver has still been appointed as a beneficiary and a lessee and is entitled to a lease agreement. So it's almost like this Kafkaesque reality where you sort of circle back to the same point. But my lady, the validity for the written lease agreement is not the minister's instruction. The minister's instruction, you can put a line through it. The validity for the lease agreement is the appointment of Cultiver as a beneficiary, which hasn't been set aside and which nobody seeks to set aside.
You are also saying the Limpopo opposition would not have tampered with this approval.
No, it didn't, my lady. And my learned colleague makes, with respect, a lot of sound and fury about how the former minister's decision prevented, sort of all of these allegations unraveling in due course. But with respect, my lady, the Limpopo proceedings were instituted at the beginning of 2017. By the end of 2018, there had been no application to review and set aside LA3, and who knows if there ever would have been. And perhaps, in a way, the most perverse part of the SIU's case, that it was irrational for the minister to thwart the determination of whether LA3 is valid or not, is the fact that when the SIU did it, they then abandoned that. So if the minister acted irrationally, well, then they've acted irrationally. And the previous minister acted irrationally because the previous minister had from 2013 until 2018 to apply to set aside that decision. But my lady, in relation to this, just to sort of, put this argument in its correct category, we've made the submission that one can't set aside a decision as being irrational and unreasonable when you don't really know what the content of the decision was, and there's absolutely no evidence that would support a conclusion that the decision is irrational. And even if you're in the realm of speculation would suggest that the decision was rational, because it's a decision that was taken, but the same decision with the same consequence has been taken by a lot of different people, including the SIU. But now, in relation to the second component of the case, if your ladyship is against us and your ladyship sets aside the minister's decision, the former minister's decision, we make the submission, well, that actually doesn't impact upon the validity of the lease agreement, because the validity of that lease agreement derives from the appointment of Cultiver as lessee in terms of Annexure LA3, which has not been set aside and which is not being sought to be set aside. And my lady, in that respect, the case of Brightwater, and with respect, your ladyship correctly pointed out that I believe there is a tension between Brightwater and the jurisprudence of the Constitutional Court in terms of the court's exercise of its discretion and the factors that a court can take into account and should take into account when granting equitable relief. But your ladyship doesn't need to get into that, because Brightwater is distinguishable on the facts. Because in this case, what the applicants want to set aside is the minister's decision to withdraw the opposition and an instruction to finalize the lease agreement. But even if one sets that aside, one leaves intact and alive a decision that nobody is attacking, in terms of which Cultiver was appointed as a lessee, and according to the department's policy, with the consequence that a lease agreement must be entered into with it. And I referred your ladyship to paragraph 7.4.1b of the PLAS manual that makes that clear. Lease agreements with an option to purchase must be concluded with the selected beneficiaries. So in that respect, this case is factually distinct from Brightwater. So your ladyship does not even need to engage in the tension, which I accept. And with respect, my ladyship, I agree there is between the decision in Brightwater and the jurisprudence of this court regarding the exercise of an equitable discretion in cases such as Gajima. And then, my lady, if I can finally just make some brief comments about the allegations of impropriety on the part of Cultiver. So we've made the point a few times and forcefully in our heads of argument that there is no evidence to support these allegations, and that in the circumstances, making these allegations is respectfully improper. My lady, we say that this is the case in relation to the decision of the former minister that the applicants still seek to set aside. But it's also the case in relation to the decision appointing Cultiver as lessee and beneficiary of the PLAS program, the decision LA3. And in relation to that decision, the decision LA3, on the evidence before this tribunal, Cultiver, it is correct, Cultiver identified a prospective property that could fall within the PLAS program. My lady, not only is there no basis to criticize Cultiver for having identified a property, but the PLAS manual expressly recognizes that it is permissible for prospective beneficiaries to do so. And if I can take your ladyship to, oh, sorry, these papers, it's hard to give references. Page 00171, it's annexure BA3 to Mr. Avenant's founding affidavit, my lady. It's the PLAS manual.
Volume?
And
which volume? Is it 1 or 2?
Volume 2. Volume 2.
Page 71.
So, my lady, the document starts at page 71.
I've got it. Thank you.
And then, my lady, at page 82, at page 00182, no, am I looking at the right page? No, sorry, my lady, 00185, 85. Does your ladyship have the page?
I've got it. Thank you.
So, my lady, just to put what I'm showing your ladyship into context, your ladyship will see in the previous page, paragraph 7.2, the manuals outlining methods of acquisition. And it says methods of acquisitions refers to how the state will acquire the land proactively. And your ladyship will see subparagraph A is expropriation. And then subparagraph B is auctions. And then I was referring your ladyship on the following page to subparagraph C, market transactions, negotiated transfers. And your ladyship will see that it says land will be acquired through normal market transactions, PLROs, which is the Public Land Reform Offices, or prospective beneficiaries can approach owners to see if they would be interested in selling it through normal market transactions. So with respect, my lady, there's nothing wrong, improper, or any basis to criticize Cultiver for having, as a prospective beneficiary, approached the owners of Mike's Chicken, and the Plas manual actually expressly recognizes that it's permissible for this to be done. Then, my lady, Cultiver submitted an application. It submitted, and if I can ask your ladyship to please turn to answering affidavit, paragraph 57, which is at P009, page 26. I'm not sure what volume that is. P009, page 26.
Yeah, I've got it. 20, did you say page 26?
No, it's, yes, page 26.
Mm-hmm.
And your ladyship will see that Mr. Twala says that, so he gives his evidence, which is that he submitted an application in which he made reference to the property that had been identified and expressly requested to be put on the list in respect of this property. So if I can take your ladyship to Annexure MT 8.1. MT 8.1, my lady, appears at page 009.80.
Sorry, please give me those references again.
Sorry, my lady, it's 009.
009.
8, and then 80, page 80.
80.
80, yes, 80. And your ladyship will see that this is an email from Mr. Twala.
Hold on,
So,
hold on.
Sorry.
Yes.
And he writes to Mr. Chilo, who's, I think, at the provincial office of the department. He says, "Dear Melton, my name is Muzi Twala. I've been trying to get hold of you. However, I'm not succeeding. I would appreciate it if you can call me, as I would like to talk to you about the lease application form, which I left at your reception a week ago." And then if your ladyship will turn over the page, your ladyship will see that there is another email from Mr. Twala saying, "Thank you for contacting me this afternoon. I attached the same application I delivered last week. Your assistance will be highly appreciated. Please register us on your list for the above mentioned property." And then, my lady, what is clear from the papers is that what happens then is that Cultiver at all points submitted to the process imposed upon it. It did absolutely everything that it was asked to do by the department officials. It exercised no control over the process. And my lady, there is nothing improper, nothing irregular, nothing untoward in the fact that one of Cultiver's shareholders had been a beneficiary of a lease in Mpumalanga. Not only is this not prohibited by the Plas manual, and my lady, in Deloitte's executive summary, it makes this point exactly, that it's not prohibited for the same beneficiary to benefit more than once. But in this case, that isn't even the scenario, because what you have is one shareholder of a company who has previously been a beneficiary. There's no allegation that Cultiver benefited before, but in any event, in the Deloitte summary, and if I can give your ladyship the reference,
Yes.
we don't need to turn to it, my lady. I'll just give your ladyship the reference. It's 001791. That's where the Deloitte's executive summary starts. The relevant page is 001815, and the relevant paragraph is paragraph 1.139. So, my lady, there's nothing untoward about it. It's not prohibited by the PLAS manual, but over and above this, it is actually expressly permitted by the lease policy. And this allegation appears in the answering affidavit at paragraphs 48 to 49 of the answering affidavit. And the page reference is 009.24. And again, my lady, there's similarly nothing improper, nothing irregular, nothing untoward about the fact that Cultiver is not indigent or poor. Again, this is expressly envisaged by the PLAS manual. And my lady, I'm going to refer you to the relevant page in the PLAS manual. Your ladyship doesn't need to your ladyship doesn't need to turn to it. I'll read the relevant portion to you, but the page reference is 00171. So it's Annexure BA3. That's where the PLAS manual starts. The relevant portion is at the relevant portion is at 00176. And paragraph 2 sets out who the target groups are. And it says, and I'm going to read paragraph to your ladyship, the framework in terms of the strategy will target Black people, groups and individuals that live in communal areas, and Black people with the necessary farming skill in urban areas, people living under insecure tenure rights. In this way, the framework seeks to contribute to the decongestion of the communal areas, secure on or off-farm accommodation, and to create sustainable livelihoods. While the approach is pro-poor, it also caters for emergent and commercial farmers. Sorry, my lady, apparently I said page, it's page 79. So my lady, to finally and quickly recap, it is the first respondent submission that no case has been made out to set aside the former minister's decision. There is no evidence. There is no evidence to sustain this case. And in any event, even if this tribunal were permitted to make a determination on the basis of hearsay and speculation, which obviously it isn't, but even if it was, speculation would yield the conclusion that the decision is rational. Secondly, even if there was a basis to set aside the former minister's decision, this does not impact on the validity of the written lease agreement. The written lease agreement derives its validity not from the former minister's instruction, but from the decision in 2013 appointing Cultiver as lessee, which decision stands and until it is set aside requires to be implemented and given effect to. And then finally, we make the submission that there's no basis to seek to impugn Cultiver's integrity and that the SIU's attempts to do so in these circumstances are improper. And in relation to costs, my lady, we've dealt with this in the final paragraph, our heads of argument, and we stand by those submissions and would ask that the application be dismissed and that costs be awarded to Cultiver, being the costs, including costs to council.
Thank you. Thank you, Mr. Roth.
Thank you, my lady. I will first deal with the two topics. First is the hearsay evidence topic, and the second is the arguments, which I think it dovetails with all of the arguments that you don't know what the decision was, you haven't got the document of the ministerial decision, etc. And which, as we understand it, actually has at its core the failure to interview the minister. It actually has at its core the criticism.
Mr. Roth, sorry, your sound is not good, and it affects my ability to follow you. I don't know if you can do anything about that. Perhaps you should be exploring a different device at this point, because that has persisted throughout.
Can you hear me now?
It's still not as clear.
Oh, my lady, I have I'm afraid I'll speak up. I hope you can hear me better now. Can you hear me now?
It's slightly better now.
Yeah, well, I'll speak out. All I can do is to speak out as clearly and as loudly as possible. I can't change my. I can't do anything about the
device
technological part of it at this moment. My lady, can we refer you to the notes? The notes.
Where do I find the notes on case lines?
The last section. It's right at the end. It's the 054 series of case lines.
Last document. Okay, I found them.
If you could just scroll down to paragraph 8 under the heading hearsay evidence.
Yes, I'm there.
Now, I'm going to read it because it'll take me. It's not necessary to address you. It is not disputed that Mkono was the head of the ministry, or as Cultiver refers to it, for the designation as the minister's chief of staff, and that Ms. Sadiki was the acting director general of the department. The evidence before the tribunal is the following. Avenant presided over the inquiry of Mkono and Sadiki. That's direct evidence. They testified under oath. That's also direct evidence. Their evidence was that they simply acted on the instructions of the minister without having any idea as to what the reasons were. Now that goes to the state of mind of the two witnesses. That's direct evidence. It's not hearsay evidence. None of them were familiar with the details of the pending previous application or the irregularities involved. The same applies there. Sadiki initially stated that there was nothing wrong with the lease agreement, as Cultiver initially had a lease agreement, which is, in fact, my lady, we will revert to that, but it was actually part of the areas of contention in the previous application. But when referred to the fact that the department's refusal to sign a lease agreement was exactly what caused the litigation, she refused to answer any further questions pertaining to her knowledge of the details of the case or of the legal opinions obtained. All of this is direct evidence which confirms that the reference in Mr. Mkono's emails to a political decision which prevailed over any legal advice as to the merits of the pending case was exactly that, and exactly because of its purely political nature. There's no hearsay evidence there.
Mr. Rath, in this tribunal, right? Not before the investigator, Mr. Avenant, in this tribunal, how is Mr. Mokono's evidence, direct evidence?
It is Mr. Avenant's evidence as to Mr. Mokono's evidence of his own state of mind, not his knowledge of something else. It's not as if he's relaying to you Mr. Mokono's rendition of what happened elsewhere or on some other occasion.
Yes, but what you are seeking reviewed here is not Mr. Mokono's state of mind. It is a decision of the minister, and that decision is being placed in dispute.
Yes, my lady, yes, that is so, but this is what we submit is a direct evidence which, if you would just bear with me, on that basis, on what Mr. Mokono and Mr. Siddiqui told Mr. Avenant, which is evidence which is not hearsay for the reasons which we've submitted. Now, just bear that in mind. Bear that in mind. And let's go to the next topic, which is actually the main bone of contention. And that is the previous minister has not been interviewed by the SIU. We deal with that in the next page. Now, firstly, exactly as it was a political, just bear with me.
I'm listening.
We take it because this is difficult. This is a difficult part of my case.
Trust me, I'm giving you a hearing. I am listening. I'm not on the verge of saying anything. I'm very attentive at this point.
I appreciate that, but I know that this is the already with the SIU. We're not with the commercial institution fighting for life and death. So I know, my learned friend knows that the difficult part of our case is the fact that the minister had not been interviewed. That is so. And we need to convince you, persuade you why the case we put up is still good enough. And that's what we're dealing with now. And it's intertwined with the hearsay argument to which I've referred, for reasons which I hope will become apparent. 10.1, exactly as it was a political decision, I'm still reading again from this, exactly as it was a political decision taken at the political level, an interview so as to determine what political considerations determined the outcome would be irrelevant. No political considerations could have outweighed the constitutional demand to uphold the rule of law through the pending legal proceedings. And I'll have to revert to that again on account of, because of the argument of my learned friend to which you've listened. The one sentence in Annex B810 says it all. Please be advised that much as we appreciate the legal opinion by counsel in this matter, it has been overtaken by political and other events, in that the minister has taken a decision that the department should grant a long-term lease to Cultiver immediately. It couldn't be more plain than that. It means that whatever may be the merits of the legal opinion, which means the case, the minister has decided. That's it.
Just remind me what BA10 is, Mr.
That lies at the heart of the...
is it one of those emails?
Yes, it is in the 001. If I could just get it. BA8. This really is.
I'm going to briefly, if I just need a minute to put my device on mains. It's gonna go off at any time. Just half a minute. I'm avoiding going under my table while you're looking at me. Thank you, Mr. Rath.
Larry, could you go to 001863?
001863. Volume?
Yes. And then the bottom, Larry, it's
The volume is the, when I say volume, it's the, you see 001 is divided into sections. I want to know which section is that.
Yeah, it starts at 001.
Yes.
It's 863. Have you
So
already
that's sub
got
volume 6. That's sub volume 6. I found it. 863. Yes. No. Sorry.
This is where it starts.
Sorry. Please give me a few seconds. Found it. Yes, I found it.
This is where it starts. 20 December at 20 minutes past 2 in the afternoon. It's from Mr. Makono, the head of the ministry, to the applicable to the officials concerned of the department. Colleagues, please be informed that we are instructed by the minister to finalize the processes regarding issuing of a long-term lease to Cultiver with reference to the property is commonly referred to as Mike's Chickens, it would be. As a result of this instruction, you are required to instruct our council to withdraw our opposition to the court application in the Polokwane High Court on this matter. It is our hope that in light of this decision, Cultiver will also, as the applicant in the current court action, withdraw such application as it has become unnecessary. Then, Mr. Mngwengwe, you are requested to do a reply letter to the attached correspondence from Cultiver and to inform them of the minister's decision that the long-term lease agreement will be finalized and signed with them and the DRDL as the department as soon as possible. Please make sure that the long-term lease is in place as soon as possible and keep the ministry informed of the progress therein. Please update the ministry further on progress by all other recent approvals by the minister that required long-term leases to be put in place. If you would scroll down. If you would scroll down, you'll find an email which refers to the letter of the first respondent. That is the letter which you'll find on page 865. That's a 22 August 2018 letter, which is annexed to the answering affidavit as well. And you will have noted in our heads that this is the only document which the first respondent can offer as to how the minister was persuaded to withdraw the opposition and to grant the lease. This is what you've got from his side. He refers in paragraph 90 of the answering affidavit to various discussions, but you have noted in our heads that it's very, there's no detail given, nothing at all comparative, which one could compare to the excessive detail of everything else in the answering affidavit. You're not told what transpired between him and the minister. Now, then if you could scroll down still, on page 869, you'll find an email to the council dealing with the matter to close the files because the matter is being withdrawn. And there's on page 871, there's an email to Cultiver. The Office of the Minister acknowledges receipt of your letter, which is a letter which I've referred to. And then you've got on page 872, the last of a trail of emails. That's actually very, very important. That's one which we've quoted from. but you'll see that there's a rather lengthy email from the officials to inter alia Mr. McConnell, setting out the legal advice received. That is the lower part of page 872. There's a discussion of what the opinion says. That's the opinion. That's B. It's taken from Annexure B 12. It's the council's opinion just as the matter was to go to, as they were preparing for the hearing of the matter, oral evidence on the matter. That was taken from the memo which they wrote for that purpose. And if you would scroll up again, because this is the end of the email trail, you'll see the answer. My computer just takes some time to respond to case lines. Top of page 872. This is the final response of Mr. McConnell, and you can see the short time frame. This is his final response, still on the 20th of December, at 6 minutes over 4, 16:06. Please be advised that much as we appreciate legal opinion by counsel in this matter, it has however been undertaken by political and other events in that the minister has taken a decision that the department should that Cultiver will withdraw their court application against the department. It will be able to make better utilization of the properties together with any other partners that they wish to be involved. That's the instruction. And in January, then I think it's 11th of January, the lease was signed. So Mr. McConnell and Ms. Vicky was interviewed on the basis of these emails. And that's the responses which they gave, which I referred you to. If I could return to paragraph 10 of the notes.
Yes. Paragraph 10 of?
10.1 of the notes, which I've been dealing with. In the middle of the paragraph, we quoted this last email, which I've now just repeated. It could not have been clearer. The political decision stands in express juxtaposition to the legal advice. That is, the legal proceedings whose merits or otherwise has no bearing on the intervention by the minister, precisely as it is of a purely political nature. That's what it calls itself. Then the second reason why we say the criticism is not valid. We know this from another source as well, Cultiver's own rendition, and more particularly the contents of its letter of 22 August 2018, it's Annexure NT 16 to the answering affidavit. Fitted as it was against the whole of the department's case in the previous application, it raised only considerations such as Cultiver has succeeded in obtaining finance for some 22 million rand. It's a black-owned company. It hadn't been in possession of the property for some time, and its financial prospects were good. There is no reference to the merits of the case, nor is the defendant willing to divulge to the tribunal what he conveyed to the minister during his alleged many other encounters with her, referred to at paragraph 90, and we should have added paragraph 94 of the answering affidavit. The third one, we know it from the head of the ministry, Mr. McConnell. As could be expected, the opponent's interview with the minister was arranged through him. We see that from the answering affidavit, paragraph 94. The minister, and this is crucial to our case, my lady. The minister is the political head of the department. She communicates with the department through her ministry. So the minister was dealing with pending litigation, defending by the department based upon the full ambit of the intricate complex structure of policies and prescripts and the various reports, prompted as they were by the decision of none less than the MCM that the forensic audit was necessary, inter alia specifically in relation to the erosion of state assets and alleged looting of bank accounts, as referred to by the then ministry in LA5. And the advice of senior counsel that it would have been irrational to sign the lease in the face of the reports. That's paragraph 66 of the opinion, Annex B12. What counts most significantly against Cultiver is the fact that in such circumstances, one would have expected the minister to have, through its ministry, communicated to the department the reasons for her volte-face, why the litigation, which was in full swing, had to be abandoned. And indeed, she did communicate to the ministry the basis of the petition. Namely, it was simply taken as a political, which is the reason why even Mr. McConnell, who had arranged Cultiver's meeting with the minister, could not tell what the reasons were. Then the last one, and this is very important as well. By far the most important consideration is this. The application has been brought against both the minister, Mr. Torke de Ziza, when the application was issued, and the department as well. Neither opposed the application. Had the previous minister's political decision been based upon considerations possessed of sufficient gravity to justify a political decision, no doubt they would have opposed this application and would have done so on the very grounds and for the very reasons which Cultiver says should have been obtained from the previous minister by the SIU. And that is why this is why we, at the outset of our argument, emphasize the fact that this is not about a particular minister who was the incumbent at the time. It's about the ministry as an institution. That institution is in fact was brought before you. They were brought before you. They were cited as one of the ministry was cited as one of the respondents in the department as well. Now, in exactly the same way, my lady, we submit that the current Director General of the department would defend some administrative action of this importance taken by a previous incumbent, exactly in the same way with the current or the minister when the application was issued, joined the proceedings and defended the decision of her predecessor. And the reason for all of this is very simple. It was an impulsive decision taken at the political level as a political decision, meaning without reference to any merits or any of the circumstances, for some political, whatever the term political reason might comprise. And that's why we say it was not necessary to interview her, to hear what political considerations she had, and what is more, apart from that, what you have before you, we submit on the basis which you've just raised now, is sufficient to come to the conclusion, if you view this matter against the context of all that is before you, that it was irrational, it was exactly what it called itself, a political decision without more.
Mr. Rath?
Yes.
Mr. Mukono, in these emails that you've referred me to, presents two versions regarding the minister's decision. In BA1 in paragraph 2, he says the minister's instruction is to finalize the process regarding the issuing of long-term leave. And then on page 872, the email you referred me to, he changes stance there. He refers to minister's decision to conclude a long-term lease. You see, there's a credibility issue here.
Already, it's the one fits into the other one was taken into account that these emails were issued.
There's a clear contradiction. The evidence you're relying on, really on what the minister's decision was, doesn't assist, because the very Mr. Mukono articulates it differently.
My lady, with respect, I think it should be read as follows. The first email is the first instruction, the first communication as to the decision. It must be finalized. Finalized is the broader term. And then within 2 hours, it is specified more particularly. Finalize means then, it explains itself, finalize to the extent that it at least has to be signed immediately. Now it says signed immediately. It means that Mr. McConnell, when he read the second email, he was giving, in fact, more detailed expression to what was stated in his first email, and he was responding.
How do we know that?
He was, my lady, if I could just say, he was responding to the email which endeavored to persuade him to rather that the action should, the legal advice should rather be followed and implemented. There's no big difference which requires explanation there, and those emails was what Mr. McConnell was questioned about. That was the center of his questioning. There's one email where it says the minister has now said withdraw the opposition, and that it must be finalized within 2 hours. When there's a response referring him to the legal advice, with an attempt to persuade him that the matter should proceed, the answer is no. We've got as much respect as we have for the advice. The minister's instruction is, and it must be the same instruction which is received in the beginning, sign the lease. And which, in fact, my lady, the withdrawal of the application means exactly that, because the application was to have the lease signed. So the very first email with the instruction that the opposition should be withdrawn means that the claim for a signed lease should not be opposed. It should be acceded to, which is the signing of the lease. There's no, with respect, there's no disparity between the contents of those two emails. Well, I have to deal with some of the arguments raised by my learned friend. The first is this. Firstly, I think you would have seen what we have stated in the first paragraph of our latest notes. LO3, the backbone. The decision in LO3 is the backbone of...
Sorry, it's a what?
It's the backbone. The backbone. The main theme of the first respondent's case, LA3. That's why you've heard about it how many times in my learned friend's address to you. Now, firstly, it's not uncommon for a party to list 5 prayers in a summons or in an application, and then not persist in 2 or 3 of them or 1 of them. Nothing strange. And the fact that we have not put up a case for prayers 3, which, by the way, doesn't refer to Annex LO3 expressly, doesn't put us in a worse place than we would have been if that prayer never was entered into the application. It's just the draftsman of this application thought it wise to add that in to keep the door open. And there's no reason why you shouldn't consider, partner from the arguments from my learned friend on the integral principle, why you shouldn't look at this application as if prayer 3 was never there. And while we say this is the case in this matter is the following. What is the difference between a review application and the reservation in pending proceedings to bring a review application? in the context of this matter. What is the difference between an application by the department in full swing at the time in the answering affidavit, asking for a review or a counter application for a review, or in these urgent proceedings, reserving the right to do so and exercising that right once the matter is referred to evidence. There's no difference. And the fact of the matter remains the same. You see, the first respondent is compelled to argue the case before you as if you have to determine the previous application. The larger part of the argument was actually designed to that end. All of the references as to how the plus manual, how it is constructed and what its ends and aims are. The reference to the fact that it's possible for the beneficiary to be benefited twice, which is correct, but as pointed out in the replying affidavit, there's a second, the next sentence reads that it's got to be balanced against the needs of more suitable beneficiaries, but it's there. But the point is this is not for you to consider with respect. It's not before you. That is what should have been made out by the court of law, who was at the point of doing that when the process was stunted by the minister's decision. And with great respect, the first respondent can raise any of the many arguments they will. What they can't avoid is the simple fact of the matter. LA3 was raised in the papers. There was a brief description in the answering affidavit of what was wrong with it. A series in 3 paragraphs, very, very briefly put in the urgent application papers by the department. And the right was reserved to bring a review application. And now you are told, my lady, that because there wasn't a review application, it still stands. And in fact, you were told towards the end of my learned friend's address that if LA3 did not exist then, and I'm not sure whether I followed the argument correctly, then a minister's decision would not stand scrutiny. Which, the point is simply this. The minister's decision flew on its own wings. It flew on the wings of some political consideration by definition, not administrative consideration, not some argument or some reasoning engaging with the problem which was before the court, just political. And it's so plain, my lady. You read it, it's there. Much as we appreciate council's opinion, it's been overtaken by political events. Sign the lease, which was what happened. So when you consider my learned friend's argument, just bear in mind the following. How much of that is based upon or is actually geared towards persuading you that the department's defense in the previous application was bad, so that you should decide it, and how much of it squarely addressed the SIU's main case? It's a very, very simple one. There was properly instituted legal proceedings in the Limpopo court. It was just about to proceed towards hearing of oral evidence where all of these arguments could have been raised and would have been raised by both parties and embroidered upon, and other evidence, quite possibly as the matter developed. And that's why emphasized so strongly that one should not look at the previous application as such, as it stands before you, as it is reflected in these papers, as the proceedings which were foiled by the minister. It is the properly developed case which would have followed. At the instance of Cultiver, by the way, Cultiver was the applicant. There's some reference to the fact that the matter had not been enrolled. Why? Cultiver was Dominus Litis. It was Cultiver who was supposed to get the matter decided, being the applicant, but it decided a different route. It wrote a letter to a minister. A single letter is all you've got. You've heard so many references to the fact that you haven't got any decision, any documents on the minister's side. But all you've got from Cultiver's side, Mr. Twala, who personally conducted these proceedings, these discussions with the minister, is that letter. And next thing, the letter is annexed to the emails which I've referred you to. And next thing, there's the political decision. And it's the end of the matter. Well, lady, then, a very, very large part. You were taken through the history of the matter since 2013. Now, there's a decision of 17 May 2013. And perhaps I should just give you the references because it's the next following references. My lady, the Deloitte report, the executive summary, which was the actual annexure to the previous application papers, runs for 29 pages, just 29 pages. It runs from, if your ladyship could just note it, make a note. It runs from 010 1108 to 1137. 010 1108 to 1137. It's 29 pages. You needn't even read it in detail, just page through it.
What is this?
The Deloitte executive summary.
But remember the difficulty with this report. It's illegible.
Yes, that's now completely legible. And then the same applies to the Van Rensburg report. That is at 010 238 238 to 263. And that's 25 pages. Again, it's not necessary to read it in great detail. I tried to refer you and it didn't work well. It was rather frustrating. I apologize for that. I tried to refer you to various parts of it. But just paging through it, you'll find in it earlier the following. It's the fact that the decision of 17 May 2013 was it was approved subject to his not being a beneficiary elsewhere, but he was. You'll find in Deloitte clear indications. What they found that Mr. Twala knew he would be a successful beneficiary at a very early stage because of certain transactions he concluded. You'll find that at the meeting, that very same meeting of 17 May 2013, the NLARC was not informed that the purchase of the land, the sale of the land had already been concluded. They were left under the impression that the price was still being negotiated. And I mentioned those as examples. And I repeat, we're not asking you to make findings on that basis. Not at all. We're asking you to consider it as materials which call for proper judicial pronouncement. and which was about to be properly pronounced upon judicially. And out of the blue, we've got a political decision stopping it all. The other important thing is this, which I want to point out. The long history to which my learned friend has taken you through since 2013, through just up to the stage when the previous application was launched by the first respondent in January 2017, formed part and parcel of the founding affidavit in the previous application. You'll read at least 70% of it there. You'll read about the lease agreement, which he signed with a business plan attached to it, which he unfortunately doesn't still have. That was part and parcel of the case made why the lease should have been signed. As he claimed in the previous, Mr. Twala, let me rather say Cultiver, applied for in the previous application. Is exactly that. Now you refer to the long periods of time. You refer to the fact that the Van Rensburg and the Deloitte reports dated from 2014. That is so. But still, what it produced was a sufficient reason for the then minister to oppose the application on the basis of those reports. It was still of sufficient value for the department at that stage and the minister at that stage to require a court of law to pronounce upon. If you would bear with me for a moment. Could you just bear with me for a moment? I just want to discuss something with my...
Okay. I can't hear you. I think you've gone on mute.
I'm just discussing something with...
Oh, sorry. Sorry. But you didn't ask to
I didn't
discuss with your junior. I thought you're still with me.
Clearly, I didn't ask that clearly enough. Malady, I'm sorry.
No, it's fine.
Now, my lady, thank you for bearing with us. You were referred to a letter of the NEF to demonstrate that their investigation was a rather, as I understood the argument, a rather shallow one. Now I didn't plan to refer you to that letter, but since it's been read to you, it must be read in its entirety. It is 010-6. Paragraph 13 on that page, and the quote is from the bottom of that page. And it's the letter of the NEF, I must immediately say, has been attached. A copy of that email is attached. The quote starts at the bottom of page 6, 0106.
Sorry, where do I find this letter?
010-6.
Isn't that their replying affidavit?
Yes, it's a quote. It's a quote.
Oh, I
It's
see.
in
I
the
see it on paragraph 13. Okay.
What we were dealing here
Yes.
with, there was
I remember that. Yes.
So again,
I'm saying I remember
didn't
being
follow.
referred to that paragraph.
yes, but let's just read that paragraph in its entirety. That quote. I have reached out to my colleague who was part of the team in this matter, and below are the sentiments which he expressed. I don't want to go to court, it should be, for this thing. I read the report after a short site visit and assessment of the financials that were given to us. I further went on to say that we cannot take a view on the business activities until a forensic audit has been concluded. I cannot comment on people's fitness to be a beneficiary or otherwise, or whether the issues were observed at the time were confirmed to be proof of improper conduct. I remember that at the time, Kutsu was hounded by these applicants with threats, and I'm not comfortable putting my name on this report. It would be one thing if we invested, but we never took this further after this assessment. Now, that is the official who was approached by Mr. Msiwa Bantu, the General Counsel of the NEF. He referred the matter to that official, and that's the response he got. Then the letter he proceeds further with the remainder of the letter. At the time, I recall that we were very concerned about the safety of our staff members involved in this transaction. If possible, I would rather not have my colleague deposing on an affidavit on this matter. Is it crucial to your case that someone depose of such an affidavit? If so, I will have further engagements with my colleague and our risk department on this. Now, my lady, we didn't take it further because this was part of the explanation. You'll recall at the case management meeting of 27 May last year, the SIU had the difficulty that Cultiver was complaining about the fact that they didn't get the source documents for the Van Rensburg, Deloitte, and NEF agreement reports. And you will recall that, unfortunately, the investigator at the time passed away shortly after that case management meeting. That compelled Mr. Ouwenaar to get personally involved, notwithstanding his tremendously busy program. And it took him only 2 telephone calls. First to Van Rensburg, second to Mr. Ramego, to find out that all those source documents were available. And that's what we've already referred to what followed then. All those documents were made available. So it's just necessary to read that letter in its full context. Mr. Ouwenaar then goes on to explain that he told the NEF that we could summon you for some questioning, but that didn't move them. And because we were in such an embarrassment already and so much of the delays were attributable to us because of what occurred, we simply referred to the letter and we went on from there. I can add to the question of the reserved right to review the Annex 3 decision, the following. And I do this because of the time periods, the extended time periods to which you've been referred. if that application was properly processed through oral evidence and whatever that might have entailed, and a counter application was brought, and if the first respondent was not satisfied with the fact that it was brought at such a late stage, it could have raised a delay point. But of course, that's also an imponderable possibility for the simple reason that if one looks at the jurisprudence on delay, especially the Buffalo City case, then even if the delay is too long, even if it cannot be excused, then still the court is compelled under Section 172(1)(8) to declare it unlawful, as happened in Buffalo City. So what would have been the outcome of such an application for review had the matter proceeded is simply not, it's just imponderable. And the main question remains, why did it not happen? Why did it have to be stopped? Malady, you've been referred to Annexure BA14. BA14 is the amendment to the lease, to the policy. Now, that really, with respect, Lady, goes nowhere. It's dealt with. I can just give you the reference. You may just make a note of it. It's dealt with in the founding affidavit by Avalon at paragraph 77 and further. The reference would be 001-55, paragraph 77 and further. And it's very, very simple. And actually, it appeared with respect from my learned friend's address itself. It only touched upon the calculation of the rental. It did not, that as such, could not correct, did not authorize simply ignoring the irregularities which occurred in the past. You can't take an amendment of a policy, amending the basis upon which rental is being calculated, to infuse life into previous administrative actions which were in fact invalid and irregular. It doesn't touch upon the matter at all. It's in fact quite understandable that when the minister's political instruction had perforce to be executed, that amended policy would be applied, which is the reason between the two versions of the lease agreement to which my learned friend referred to. But just to be sure that you are in the picture there, the first version of that lease to which you've been referred, it was appended to the answering affidavit in this case, but it was also appended to the founding affidavit of Cultiver in the previous application. That was the lease which it wanted to have signed in the previous application. So it's the fact that they were an account of this amended policy, the lease was calculated differently, with respect goes nowhere for purposes of this case. It was argued that, if I followed the argument correctly, and it is it's been stated in the founding of, it's been stated in first respondent's answering affidavit in the previous application, allegation was made. It was again made in the answering affidavit in this application that the lease was regularized, or his application was regularized. Now, I'm going to refer you to 001, page 837, please. 001, page 837. That would take you, that should take you to Annex 11, which is the previous minister's affidavit. Now, it's late in the day, my lady, but if you would refer to paragraph B, section B of the affidavit, the answer, you'll see that the suggestion.
Yes.
You'll
Paragraph.
see it's paragraph 8. It starts on page